I had tendered at last Monday, but somehow that it could not be numbered till yesterday. It is likely to be numbered today. But the last date is on 9. Maybe listed on Monday before the signed by.
Give the memo.
With number.
Yes.
Item 30 today on today's list board. The option is tomorrow.
Item
30 on today's board, your lordship. Man's option is tomorrow. Can we have it on 12 or whenever your lordship before rising?
all right.
Kali option.
Your lordship.
Great.
The matter, your lordship directed to list on 23rd.
What is the matter?
Criminal appeal matter.
Criminal appeal for what?
For bail.
Give it.
Your lordship mentioning this memo for CRLA. And the appellant is in custody since 2023.
For bail?
Yes.
Please give it.
This is a repetition challenging the order of Central Administrative Tribunal. Wherein this matter was, while this matter was heard on 26/5/2025, some relevant documents were required. That is why, as per our prayer, this matter was referred to 14/7/2025. In the meantime, contempt proceeding is going on against me, against this contemptor, and date is fixed to 7, just Monday manner. On that date, he has been directed to appear personally and to pay fine of rupees 10,000.
What can be done? You take
I
time.
have filed an application, interim application, so that matter can be listed on
No, you take time there. Why? You will not comply the order. You will.
personal appearance for it.
Yes. What happened? Personal appear not appear through virtually. It's not necessary that nowadays you are to appear because
And
the Honorable Supreme Court decision.
cost.
It is not necessary that person means he should come to the court. Appear through virtually and answer to the query of the judges, the presiding officer, that why have not complied. Tell that it is pending before the Honorable.
That has also been prayed before the.
Sorry. Yes. Next. Press admission for what? Give it.
Has been assigned by Honorable Chief Justice. Your assistance. The matter relating to challenging ECI.
Challenging
The ECI Amila, the PML Act. In the meantime, the petitioner exonerated from the charges. And the matter listed on
charges. If you have exonerated, why have you filed the writ petition?
that challenging PML Act. That in the schedule.
What is the great pressing urgency?
My matter, the urgency that the proceeding already gone. That
Predicating offense is vast. So therefore PML has to be dropped. That's what.
Give the memo.
Outside
See that next week.
Yes. And that we can do.
Yes.
Yes.
Take your breath. Take your breath. Yes.
Relax.
Relax.
1 minute. Relax. Yes.
Yes, Mr. Pari, what do you say?
My lord, it is item number 1. It is a case where a person is working with the postal department and he sustained injury because
Sit down. We'll take after this matter. Yes, what is the challenge, Mr. Pari?
he is challenged the Annexure 1 order pronounced on 17/4/2024 by the Lord Central Tribunal. The relevant page is page 42.
What was the prayer of the opposite party in the before the tribunal?
The prayer of the petition is that he is entitled to get the regular pension and whatever claim has been settled.
Regular pension.
Regular disability pension.
It is mentioned that he is prayer for disbursement of lump sum compensation in lieu of disability pension.
Yes.
That was his prayer.
Yes.
And that was perhaps allowed by the Central Administrative Tribunal.
Yes, ma'am. That was allowed. We have also lump sumly settled the same by reference to the provision of law that is we have narrated in the CCS rule 6
paragraph number, Mr. Pari, please come to paragraph number 17 and 18, which are the relevant paragraphs.
Yes, ma'am.
Page 42.
Page 42. Yes.
Yes.
In the present case, the claim of the applicant is also for payment of the lump sum compensation in lieu of the disability pension, which comes under the purview recurring cause of action, and thus the rejection of his claim by applying the rule 6 is held to be made as per the law discussed above. In view of the facts and discussed above, that it was the responsibility of the head of the office to take necessary action for grant of disability pension within a time frame, and also that the case cannot be rejected on the ground of delay. The case of the applicant rejected solely on the ground of delay is bad in law. In view of the discussions made above, it is held that the account showing without examining the role positions as discussed above objected to the proposal of the SSPO throwing the blame of the applicant, which at no strength no stretch of imagination can be said to be legally tenable. It is seen that the SSPO by order dated 13/6/2019 MA11 rejected grant of compensation based on the letter of the account showing dated such and such, and as discussed, the said objection of the account showing being held to be not legally sustainable. The order of rejection dated 13/6/2019 on MA11 is hereby quashed, and thereby the order passed by the SSPO Bhubaneswar division dated 3/30 or 1/2015 MI6 is directed to implemented. The entire deal is directed to be completed within a period of 90 days from the date of receipt of this order. My humble submission, my lord, I am
No,
not.
Mr. Pari,
My lord.
Union of India is challenging a paltry sum of rupees 1,80,000.
That is,
It's a disability pension. And
you
in
get
view
to
of
be
that,
injured in
you
a
should
wrong
think
path.
it in a broader angle. How much money is spending by the Union of India? So if this sort of litigation, that is the reason why there is increase. State is filing similar type of petition. Union of India is filing 1,83,000 is just the compensation amount to a disabled person. He has lost his limbs and he was
Get to
treated,
75% injury. My.
it's all right. This
We'll
is
keep
not-
the question of law open and dismiss it.
This writ petition has been filed by the Union of India
My lord.
challenging the order dated so and so, passed by so and so. It appears that the opposite party Pranavanda Das filed the original application with a prayer challenging the order dated 13/6/2019, rejecting his prayer for disbursement of the lump sum compensation of Rs 1,83,823 in lieu of the disability pension, and for a direction to the petitioners to pay the lump sum compensation towards the capitalized value of disability pension. From the factual scenario, it appears that the opposite party was working as postal assistant in Satyanagar, NDT, SO Bhubaneswar, and he was severely injured in the parcel bomb blast, which occurred on 3/1/2002 while on duty, and he lost one hand and one leg. He was admitted in the SCV Medical College Hospital, Qatar, and remained under treatment from 3/1/2002 to 13/10/2003. And as per the advice of the doctor, he remained on rest from 14/10/2003 to 20/10/2003, and he remained under treatment in Nirtar Olatpur, Qatar, for fixation of artificial limbs from 21/11/2003 to 26/5/2004. The opposite party reported the duty with all medical certificates and produced the disability certificate issued by the District Medical Board, Khurda, Capital Hospital, Bhubaneswar, and certifying him to be 75% disabled. Though the authority concerned considering the disability condition, retained him in service, and leave was sanctioned in his favor for the total period of 2 years, 4 months, and 24 days under the provisions of disability leave and hospital leave as contained in CCS Leave Rules 1972, and he retired from the service on attaining the age of superannuation on 30/10/2010. And
30/11 man.
his superannuation pension was also sanctioned. But when the petitioner submitted an application for sanction of the disability pension in his favor, the same was forwarded to the Director of Accounts, Postal Cutter, and the director advised the senior postmaster Bhubaneswar GPO to examine the case of the opposite party as per the extant rules and guidelines. And ultimately, since no fruitful purpose came, the petitioner approached the London Central Administrative Tribunal in OA number 836 of 2014, which was disposed of on 24/11/2014 with direction to the petitioners to consider his representation. And the petitioners, after considering the representation for sanction of disability pension by order dated 22/11/2015, rejected the same. Further application was submitted by the opposite party on 27/1/2015 for sanction of capitalized value of the disability pension in lieu of disability pension, and the same was considered by the authority, and the SSPO came to the conclusion that the opposite party is eligible to be paid lump sum compensation of the amount equal to capitalized value of the disability pension in lieu of disability pension.
The ground of delay there, rejected.
When the petitioner did not get the relief and it was rejected on the ground of delay, the
Not only delay, he also another point is there, the disability pension cannot be given to a person who is at government service owing to disability. That may be working.
No, para 37 says it's your responsibility, you have to give it under rule 4.4, amended rule.
The petitioner, the opposite party challenged the same, and the London Tribunal, after considering the submission made by the land council for the case of the opposite party. So also the petitioner came to hold that the claim of the opposite party is for payment of the lump sum compensation in lieu of disability pension, which comes under the purview of recurring cause of action, and therefore rejection of his claim by applying Rule 6 of so and so was held to be bad in law. It was further held that the responsibility of the head of the office was to take necessary steps for grant of disability pension within a time frame, and the case of the opposite party could not have been rejected on the ground of delay, and therefore the rejection on the ground of delay is bad in law. In the operative part of the impugned order, it has been held as follows. Quote paragraph number 18. After hearing Mr. Pari, Lenin, Deputy Solicitor General, and going through the averments taken in the writ petition and the discussions made by the Lenin Tribunal and the relevant rules discussed by the Lenin Tribunal, we find no infirmity or illegality in the same, and more particularly when the amount which was claimed by the petitioner is not a huge amount, and he was just to get the same as a lump sum compensation for the disability pension, particularly when he received the injury while on duty on 3/1/2002 and was continuously under treatment in different hospital, and there was fixation of artificial limbs. We are of the view that in the interest of justice and equity, the impugned order should not be allowed to be interfered with. Accordingly, the writ petition being devoid of merit stands dismissed.
Okay.
Yes,
Well, allow me, Mr. Panda appearing, and I may be replied. Jay Panda.
that. ऊपर लिखी देवे. The office has pointed out that in the post title of order number 1, the name of the opposite party has been inadvertently mentioned as so and so. Stop. Let the name of the opposite party be read as a character. Yes, please. Next.
Yes, yes.
Acha, hi, madam.
Since we have the present appellant has been in custody since 10 years and the
Give them,
fourth
give-
person has been
Give them, man, give them.
Item 2.
During the secured days, the bank is the petitioner.
Section 14.
Section 14 application has not been considered for more than one.
What is the status of the application? Walk-in instruction. This writ petition has been filed by the State Bank of India for a direction to the District Magistrate Jagatsinghpur, bracket opposite party number 1, for expeditious disposal of section 14 of the Surface Act application. What is the number of that
They have
application?
not given us any number also.
Which is filed on 8/4/2024. The Land Council for the petitioner submitted that the number of the application has not been furnished to the petitioner. That is how it could not be mentioned in the writ petition. Copy of the writ petition has been served on the Land Council for the state. Let the Land Council for the state obtain instruction from the opposite party number 1 relating to the status of such application. Put up this matter in the week commencing from 14th of July 2025.
Item 3.
Please give us. Yes, Mishra.
May I please, Your Lords? My Lord, this is the government in Works Department decided to acquire land for construction of ring road through private negotiation. Now, my Lord, Your Lordship will see.
It's a land acquisition matter. It has.
No, and I'll just clarify. Let me just clarify. This matter was placed before Your Lordship sitting with my Lord Justice S. Rath. When Your Lordship was dictating the order directing them to reconsider consider my claim, Honorable Justice S. Rath expressed that the petitioner may be related to him. Therefore, the matter was directed to be placed before any other bench. And then when now I mentioned, the matter has been placed again before Your Lordship because Honorable Justice S. Rath is no more a member of this bench.
No, it should go to appropriate bench.
Why the, no, I just heard.
No, Chetty, Boston, my Lord Justice K.R. Mahapatra,
Oh, acha, again that same thing.
it cannot go there. Therefore, this has been possibly by order of the Honorable Chief Justice.
No,
There
no,
must
no,
be
no.
something.
We have seen that order.
No.
We they wondered that why it's such.
I should have explained, then I thought
No, it's all.
maybe I will be misunderstood. I didn't say that.
Yes.
My-
So your land has been acquired.
My land has been acquired.
Hmm.
I beg to only draw one condition with regard to acquirement, Annexure 1, page 12. Privately kale. It can be acquired through a notification
Yes.
by private negotiation. It is
No.
privately kala bale, condition rakhile, average sale price of kism of the case land, as well as similar type of case land situated in nearest village or nearest vicinity area, obtained from proper revenue authority, duly authenticated by next higher concerned revenue authority, should be kept as a record for all future verification. Say rate answer se mane karibe. My grievance is they have got this LDD executed by putting the valuation at 24 lakhs.
You have submitted your representation.
Yes, my lord. I am only praying in the light of my claim, they should consider within a time bound
The
period.
last representation is dated 30/11/2024.
My lord.
So who is to dispose of your?
My lord, I will humbly pray collector, because land acquisition officer will be undone. Collector is the authority.
After this letter has been issued
My
by you to the collector,
My
have you not received any communication?
No. Even not today.
So consider his representation.
That which I am praying.
The land
We
has
are
been,
not expressing any opinion. Just
My
let on. This writ petition has been filed by the petitioner Vinod Chandra Ratho with a prayer for a direction to the opposite party to pay adequate compensation as per the benchmark valuation in lieu of acquiring the land appertaining to plot number 2717 under Khata number 703/1397, measuring part of so देखिए prayer कर लेते हैं.
an area of भूले part.
हाँ सब चीज़ देखिए ले. The Land Council for the petitioner, the Land Senior Advocate, Mr. Mishra, submitted that even though the land was acquired by way of
Personal private negotiation purchase.
private negotiation purchase way back in
And that is in 2020-21
way back in 20.
when the valuation was much more.
No, but the representation, first representation is dated 25/11/2020 as per Annexure 5 series.
My lord.
How can we representation be made prior
No.
to the.
Sale deed is of the year. Sale deed is of the year. I'll just point out. Sale deed I have annexed. That is of the year. It is after that only.
2020, that is it.
Right.
2010, 11. Way back in 2020, and a sale deed to that effect, which is dated 2010-2020, has been annexed to the writ petition in spite of filing several representation before the authorities to pay adequate compensation to the petitioner. No fruitful result has come out. The Land Council further submitted that the last representation was submitted by the petitioner on 30/11/2024, which is annexed to the writ petition as Annexure 5 series, and submits that a direction may be issued to the opposite party number 3, Collector cum District Magistrate Ganjam, to consider the representation in accordance with law and communicate the decision to the petitioner within a stipulated period. Stop. Land Council for the state has no objection to such submission made by the Land Senior Advocate, considering the limited nature of grievance of the petitioner. And since the land of the petitioner was purchased way back on 2010-2020 by way of registered sale deed, and he has not been paid, it is stated that he has not been paid adequate compensation, and a representation to that effect is pending since 30/11/2024. Without expressing any opinion on the merits of the representation, we direct the opposite party number 3 to consider the said representation in accordance with law, and from the within a period of 3 months from the date of production of the certified copy of this order, along with a copy of the writ petition, and communicate the order within a period of 2 weeks from the taking of the decision. Needless to say that if for adjudication of the representation, there would be necessity of personal hearing of the petitioner, the same can be afforded.
So grateful.
Okay? Yes.
Grateful, madam. Again, sir.
Item 4.
Item 4, pursuant to Lordship's order dated 19/6, I found a copy. In this case, I think Mr. Senior Advocate Mr. S.K. Paddy will enter appearance. I have talked to him.
Yes, Mr. Paddy has already entered his appearance. We need 3 weeks
The
time.
appearance memo. Have you filed the appearance memo?
I'll give the.
Just give the appearance notice.
uh,
And what is the prayer, Mr. Samantra?
Let only consider my representation for one-time settlement. And
Any, what is that representation?
representation is not, a scheme was floated by the opposite party corporation for settlement of outstanding dues by one-time settlement scheme. That
So have you taken the instruction whether the prayer which has been made, it is just to consider that if there is any OTS proposal,
Yes, Your Lordship, in this similar matters were posted before this honorable bench 2 weeks ago, which has been posted to August by this honorable court. So what we pray is let this matter come along with those matters.
can you give the number
I'll
and the
give the
date?
numbers and the date today itself.
Okay.
I take
And in the meantime, you take the instruction.
instruction and
Okay. Look, what is your good name?
Piyush Panda.
Please give. So also submits that Mr. S.K. Paddy, Land Senior Advocate, is supposed to appear for the opposite parties epical, and appearance memo will be filed by next week. Stop. The writ petition has been filed by the petitioner so and so with a prayer for a direction to the opposite party corporation to accept the OTS proposal submitted by the petitioner under Annexure 4 in response to the later under Annexure 3, and to issue NOC in favor of the petitioner company by accepting balance amount, if any, towards the said OTS proposal. The Land Council for the opposite party submit that he has received the copy of the writ petition and may be given some time to obtain instruction in the matter. Further, he submits that similar matters in so and so is subjudicated before this court and is posted to so and so date. List this matter along with so and so on the date fixed. Hello? Yes.
Item 5.
The opposite parties have issued a notice under Rule 8(6) of Satisfyer under Annex 6 Act page 30 manner. Without giving opportunity to the petitioner to pay the dues which has been pending till date, and they are trying to sell his land, and now the matter, they are also trying to get permission from DML.
How it is maintainable here?
Well, so far as
In your
section-
Bafna case, have you gone through that sale notice has been issued? If you want to challenge the same, your alternative remedy is available.
So far as my knowledge is concerned, my lord, kindly have a glance to section 13 of Surface Act.
Have you gone through the Bafna decision?
Hmm.
Go through the decision and see that how it has been interpreted. That why it is not maintainable, why there is an amendment to 13(8) of the Surface Act, and what is the purpose, and all these things have been discussed that this court once. Liberty is always with you. Listen, this writ petition has been filed by the petitioner Paresh Kumar Paridam, challenging the what are you challenging here? Sale notice.
Yes, my lord.
Sale
Under Annex 6.
sale notice dated so and so under Annexure 6.
And
With a further prayer for a direction to the opposite parties to consider the grievance of the petitioner under Annexure 7 to grant him the benefit of the OTS deducting interest within a stipulated period. In the case of Bafna of say relevant paragraph of outcome, since alternative remedy is available to the petitioner, we are not inclined to entertain this writ petition. Accordingly, the writ petition is disposed of. Sorry, once we say that we are not inclined to entertain because the alternative we cannot grant you such relief. You as soon as possible go to the tribunal and seek for remedy.
Item 6.
Lordship. A limited prayer, I will not go to the background of the case. So far, the process adopted by the opposite party number 1 and 2, by taking possession of the land and ultimately putting it in auction, is violation of the act and rules. And I have ventilated my grievance before the tribunal. And the appeal is pending before the tribunal. One of the prayer of mine before my lord is that direction be given to the tribunal to dispose of the appeal within a stipulated period.
That is DR80, it is pending. Kolkata.
Appellate Tribunal.
Appellate Tribunal. DRT.
Your lordship may have a glance.
2025 रो पुराना केस थी वो ना.
This is an important case for him.
Kabu case तो important.
They have already entered into action.
Mr. Mahapatra, a type रो आसिला several prayers. आमे किसी केस रे कॉलू जे शीघ्र ये परियागु देखला वाला केस ह्यूज लिस्ट पुराना केस ओडा एटा 2025 रो केस टे डायरेक्शन दे देले माने फ्लड गेट चली आसीबो सब मैटर रे पिटिशन पडियो सो व्हाट वी आर टेलिंग दैट वी आर ग्रांटिंग लिबर्टी टू मूव एन एप्लीकेशन देयर फॉर एक्सपीडिशियस हियरिंग assigning the reason that why it is urgent and that shall be considered in accordance with law. That order we are passing. So similar. All right. This writ petition has been filed by the petitioner Jitendra Kumar Rao with a prayer for a direct inter alia with a prayer for a direction to the London DRT cutter for expeditious disposal of SA number 40 of 2025. The Mr. Mahapatra and senior advocate appearing for the petitioner argued that there is urgency in the matter and therefore the direction may be issued in that respect. When we put a pertinent question to the land council for the petitioner as to whether any such application for expeditious disposal has been moved before the land DRT, assigning the reasons, the answer was in negative. Accordingly, we dispose of the writ petition, permitting the petitioner to move an application before the land DRT cutter for expeditious disposal of SA number 40 of 2025, assigning the reasons for the same. And this court expects that same shall be considered in accordance with law.
One more prayer I want to add. After going through the writ petition and the act, I am very candid to say that this is the first case so far the act is concerned I am conducting. I found that there are so many irregularities. If any ancillary petition will go, the appellate court will consider.
No, that is the.
Apart from the hearing of the matter.
In such type of matter, Mr. Mahapatra, that is the original court. So you can raise all your points and he has to consider.
Exactly.
And of course, there is an appellate forum also available with you. So nobody would prevent at that stage because he has got wide power also. And ordinarily what they do is to grant some deposit, some amount, all these things, they pass the order. So, and there is several decisions of the Honorable Supreme Court and this court that don't entertain article writ petition because there is an alternative remedy. Okay? Yes. Yes.
Item 7.
7 minutes. I think 7 will also make, we will also, after identity review petition will not say, the sole petitioner and opposite party are bad matter. So then I have tried the substitution of the petitioner for the opposite.
Which appearing for the respondents or it has notice has to go. So how many interim application notice has to go? Tell us just one by one. IN number 149, then
149, that is the substitution of the petitioner, your lordship.
Oh, I see.
152, 153 and 154. In that case, notice of
No. Gote hochi 150, ଆଉ ଗୋଟେ hochi 151, ଆଉ ଗୋଟେ hochi 152. Either notice.
IN number 149, 150 and 151 is for the substitution and abatement and limitation of the petition.
Notice କୋଉଥିରେ ଯିବ ଟିକେ କୁହନ୍ତୁ
152, 53.
ଆପଣ ତ ଗୁଡାଏ କଣ ଆଇଏ ଫାଇଲ କରିଛନ୍ତି ସେଇଥିପାଇଁ ଆମେ ପଚାରୁଛୁ
52, 53, 54.
52, 53 and 54 এই তিনটারে নোটিশ দিব অপোজিট পার্টি মধ্যে সেয়া কোন লিখুন IN number 52 of 2025 this is an application for so and so issue notice করে দিଅନ୍ତୁ repudiate so and so to be filed then 53 also this is for this same prayer and IN number 154 of so and so condonation of delay so and so hello notice you file the repudiates by next week and it will be listed after so and so and objection if any to the interim application be filed in the meantime. Yes.
Item 8.
On reference to senior evidence, the Bansi the Bar Act favors not added.
You are appearing.
I'm appearing for OSFC, Odisha State Financial Corporation.
The 2008 from
2008 matter, my lord, we have taken over those properties under section 29.
Yes.
They say that there are two lots. One is lot 1 and lot 2. Those are all industrial assets, my lord. He could not give the OTS, he could not comply with the OTS terms and OTS was rejected. Thereafter, my lord, auction took place and after negotiation, my lord, because after auction there was a negotiation and my lord, possession and sale has been done. Then it was given to two persons, my lord, the plant and machinery and the land. Now what has happened, my lord, meantime, it has got further transferred to some other persons. So, my lord, this is a long, 2006, my lord, we have taken over those properties. Now, after so long, he wants to challenge those auctions and he wants to.
Where is the property situated?
Properties are in Kalapada, Bhubaneswar.
Tangi.
Tangi, Bhubaneswar.
While
So,
school is going on and their Matru Bhavan.
he says that these are mortgage property of his mother, so we cannot auction it.
2008 ମସିହାର ରେଟ୍ ପିଟିସନ 17 ବର୍ଷ ହେଇଗଲା।
The property has changed hands and those interest has been created by now. They are also necessary party. Without hearing them, we can't do anything.
The recent purchaser, he has been added as a party.
No, madam.
That's what has been.
Right to redemption, my lord, 78 Supreme Court, that also, my lord, is now frustrated. Now let us Supreme Court
That
decision.
case is based on the principle of natural justice, but he has not challenged the auction notice.
Polite mention is made on
Maker
behalf
has
of
already
Mr. Vanshidhar Bag and senior advocate for adjournment till next week. The land counsel for the Mr. Patnaik land counsel appearing for the OSFC, and you are appearing for whom?
I am appealing for OP number 3 and 4.
Also appearing for opposite party number 3 and 4, oppose the prayer for adjournment. Be that as it may, is this matter. We are fixing it to next Friday.
Next Friday, no problem.
11th of July 2020.
Next Friday, problem.
Your problem.
My lord, Wednesday also at least. Not 10th को भी असले भी होगा.
10th से जो मंगलवार और गुरुवार से उड़ा आउट बेंच ये हो
चल बुधवार को असु
बुधवार so this matter on 9th of July 2020. Yes,
much appreciated.
Item 9.
From 9 of the order of Grievance Redressal Forum, under the Electricity Act 2003, that is under challenge. However, in the meantime, the order passed by the Grievance Redressal Forum, that has been complied with by the petitioners.
so we don't want to press. Just file a memo for that.
Dispose of this.
Yes. The land counsel for the petitioner files a memo indicating therein memo in the memo is taken on record, the writ petition is disposed of. Yes.
Item
Any interim order was there earlier? Interim order stands back. You are for the petitioner, no?
My lord.
All right.
Make clear, Lordship.
Yes.
But in this case, actually, twice the matter has been heard, the judgment has been reserved, and again came back for hearing. But there is a note.
Before some other bench. No, I thought that it was.
This is first time.
I have never released the matter after hearing.
I'm
Yes.
sorry.
So be rest assured, if we hear, we'll deliver the judgment. Yes.
I expect that manner. That is why I'm before the Lordship.
Yeah.
But I filed a written note. Both sides have filed written note. I think it is there on record. If you also kindly have a look at it. The reason of indicating about the written note is that the date chart annexed to it.
Okay. The opposite party land counsel is there.
Yes, I'm.
Okay. And we hope that the pleadings are complete.
Yes.
Okay.
Pleadings are complete.
Okay. Please start.
But kindly have a look at the note that was filed.
Yes, there are 2 notes filed, 1 note.
2 notes have been filed. One by the petitioner and one by the opposite party.
No, petitioners.
12/2024.
Petitioner's note is with us. Then another written note of submission by whom?
That was 5/12 also.
That is OP number 1.
Yes.
Okay. So we are just now holding your note.
Yeah, petitioner's note.
Right. What is the challenge in this writ petition?
Sir, actually what has happened,
and OPS amount was fixed. I paid the entire amount. They say you have to pay delayed payment interest.
Okay.
Part of delayed
So
payment
obviously you have not paid the OTS amount as per settlement within time. So there was
within
delay.
time,
Right. Yes.
So they extended time. They say you pay delayed payment interest. Then they record the OTS. Then again, I filed an application. I have paid the entire amount. Kindly reconsider. They have considered saying that you have to pay this much of delayed payment interest. Then I paid that delayed payment interest. I filed an application to waive it, part of it, which is compound interest. Then they waited for 12 years. Then say it will be recalled. Then again, they say you deposit such an amount, 10 lakhs amount. I deposited that amount. They accepted it. Then they say, no, on 29, you will seize it. On the ground, actually, when the entire amount was paid, there is a portion of it has been utilized for the industrial purpose. Portion was vacant.
Now, what is the due now, according to them?
So due, I'm coming to that. I'll definitely explain what's the due. That's important. Then 29 application was, 30 application was given. Then 29 application was given. I filed a writ application for the Honorable Court. Honorable Court, after hearing entire thing, when I said that I have already paid, but there was some delayed payment interest, Court said, are you interested to settle the amount in OTS? I said, yes, I can again pay because he is a bona fide person who can pay. Then Court observed, petitioner should apply under OPS 2011 and the opposite party should consider it. Sir, OP was present. At that time, there was allegation against me was that a portion of it I have let out to two different parties. So mortgage has been given to the industrial unit. But I have let out the same. They are aware of it. Court said, all right, the tenant should pay the rent to the OSFC. That will be kept in a separate account. So I also agreed that it will be kept in a separate account. When I applied for OTS, they said that you deposit this amount, 10% of the amount. I deposited 10% amount. They said some deficit is that you deposit. I deposited. They accepted everything and rejected my OTS application. The ground of rejection is that malfeasance. But here question of malfeasance doesn't arise because I have already paid you the entire amount. And secondly, you know that tenants were there and they deposited the rent recently. They allege that you have already sold the machineries. But I applied before them that I'll sell the machineries and I'll deposit the amount. And I have also done that. Because I have to get some money to deposit. I deposited. Not that I have misappropriated. So that rejection order is the subject matter of challenge. My sole contention is, if you are agreeable for a notice, or directed to me to apply, you accepted the fees, you knew about the events, you cannot now turn around and say that is reject on this ground. So Honorable High Court has said, on technical ground you cannot reject OTS. You have to assess and say what is the amount as per the 2011 OTS, if there is a direction. My sole contention is that till the date of rejection, whatever was the due amount, the court directed me, that amount on the basis of that OTS has to be fixed. That is the law, in fact. And the Honorable High Court also in Justice Gopal Moore Division Bench, in one of my cases, also direct case, he refused to adopt the 2007 OTS. Court said no, the rejection is wrong. That was also a malfeasance. Court said no, on technical you cannot reject. You accept it, consider whatever the amount you deposit. So that is the subject matter of challenge. But I challenged it way back, kindly say 2019. 19 was the rejection order. But now 2025. They are going on multiplying it. One of the basic feature in it, each notice contains a different capital principal amount, which is not permissible. Capital is one, but the principal amount is one. You can't go on changing it.
Keep on adding the interest and make it capital.
But not only that, the compound interest they are adding, no ledger, no account, no details. Supreme Court said you have accepted money, you have not produced the ledger, you cannot claim the amount. The court director, Honorable Justice Sonangi directed to file the document. We don't have anything.
But you are agreeable to pay the money as of 2019 or 11?
Yes.
19. As of
I am talking
19.
about 2011 OTS, let me say whatever.
OTS scheme is 2011, but till 19, whatever is due.
Yes,
That's what you see.
that is exactly my prayer.
Let us put, if they agree, why should we hear it? If they agree to that.
Conclusion.
Apply 2011 OTS.
That was the
OTS.
order of the this court also.
Yes.
Yes, ma'am.
Is it not the order that you are to apply this 2011 OTS scheme
Yes, that's
and settle
considered and rejected in the imperial.
the?
The ground stated there.
What is the ground today?
Yes, ma'am. Will get lordship.
No, let us go to the order of this court first.
Yes, right.
That page 40, prior to that,
40.
page 42.
Annexes? Yes, 40. Annexes for 15.
This starts at page 40.
Yes.
The operative portion, the order starts at page 42. So kindly turn to page 43, last paragraph. While the matter stood thus, the corporation, after a period of 10 years, instead of considering the request made by the petitioner company, issued another demand notice on 22/9/2012, 10 years afterward, and see, after the payment was made, for a sum of 85,22,000 some odd, referring to the loan recall notice dated 23/2012, and claimed that such notice is in force. If further contend that the demand notice issued on 2012, after a period of more than a decade from the date of deposit, the entire OTS amount of 28,50,000, which was the OTS amount which I deposited, maybe, of course, delayed, some delay was there, is illegal and arbitrary. However, after discussion with the corporation, this is important knowledge. The petitioner company deposited the interest calculated on 28/9/2012 plus full and final settlement of the interest for delayed payment, that is 10,88,723. That was also deposited. The 10,88,723. Requested the corporation to issue no due certificate. Annex 7. Instead of issuing no due certificate, another notice was issued by the corporation 31/1/2013, intimating the petitioner that 1 year after that the petition, the proposal for condonation of delay in payment of OTS dues was placed before the recovery committee, and the committee raised question against the action of the petitioner in letting out the properties to Indian Express. For a let out, they have no concern. I have to pay the amount. So letting out one of the portion of the premises doesn't deter anything, it doesn't take away the right of mortgage. While such observation of the committee requested the petitioner to furnish the date when the factory premises has been let out and the monthly rent received from Indian Express, thereafter, without acting upon the previous loan recall notice, another notice on section 30 was issued on 22/2016, 4 years after. Let's see the conduct of OSFC note. The petitioner had given a reply to the said notice on 25/3/2016, reiterating the earlier irregularity and illegality which was not considered the corporation. Without considering the same, the impugned notice has been issued. Hence, the present writ application, and a counsel for the petitioner further submit that one-time settlement has been floated by the corporation, and the petitioner company may be permitted to avail the benefit to settle the loan. I said I'll do square of the thing. On the latest OTS, I'll apply and get it resolved. I will pay the differential amount, whatever due they can demand. Counsel for the corporation submit that due to non-payment of the dues of petitioner in terms of the earlier settlement, corporation has taken over possession of the assets of the company. He further submitted that one-time settlement scheme which was floated by the corporation in 2007 is no more existence. So I don't want also. However, another one-time settlement has been floated in 2011, which is still in existence, and it is open to the petitioner company to avail the said benefit. They themselves offered. You avail it. Because they knew at that time it was let out to others. They knew that the machineries have been sold and payment has been made.
Even then they say that 2011 you can take.
Sir, 2002 it has been over. 10 years after they are issuing notice.
Considering
the above, we dispose of the writ application with the observation that in case petitioner files an application to settle the loan within a period of 2 weeks from today, in such event, opposite party shall consider the same
But this consideration is a positive direction. This consideration is not option given to them.
Shall consider the same.
But shall consider the same as per 2011 scheme, take a decision thereon and expedite. Decision means not on technical ground, decision on merit.
Yes.
Preferably within a period of 4 weeks thereafter, after giving opportunity to the hearing, so interim order shall continue. That means the deposit of rent shall continue till a decision is taken by OFINO 1 2.
Where is the rejection?
Regarding settlement of the account, kindly mark this word. That means court directed you settle it. Regarding settlement of the amount. But kindly see, I have deposited the amount, the documents I have filed.
And that's not disputed. So are the impugn.
They deposited, they accepted, then they rejected. Kindly see the rejection.
Impugn rejection.
Annexure 19.
19.
I'm sorry, 21. 20. And all the periodical deposits they asked, I have deposited. That all those documents are there.
This is a rejection.
13/8/2019.
Which is subject matter of this writ petition?
Yes.
Okay.
Page 57. With reference as above for settlement of loan account, the company in OTS 11 scheme, we are intimating you that following observation are made by the corporation after careful examination of your proposal. The personal hearing was not given. The court directed to give personal hearing. The plant and machineries financed by the corporation and hypothecated to the corporation are missing, and the mortgage premises has been let out to unauthorized with amount to an act of malfeasance. But they knew I have sold, I have deposited the money. They knew I have let out the same. I have admitted in court.
That interim order is even today continued.
Rent has been deposited before them to keep in a separate account. But this cannot be acted as malfeasance. The reason being, all these things have been done because I have already paid the entire 28 lakhs.
No, the second
is rental income generated by subletting the mortgage payments were retained by you and not paid to the corporation. I am not supposed to pay. Rent.
No, but there is an interim order to deposit.
Thereafter, it has been paid. I didn't pay. It has been paid by the tenant to them. Prior to that, they are prior to that. So prior to that, they are not entitled to rent. Property is mine. Only mortgaged. I cannot create a third party interest. Rent is not third party interest. Right? Then you have not submitted the document sought for by the profit and loss account net worth certificate. I don't know what this means, man. I'll give my business account or a profit and loss account to them. But no opportunity, they rejected OTS. And claimed again compound interest in 2019, 1.72 lakhs.
Yes, sir. How will you justify this?
From the OTS 11.
The problem with the corporation is whoever doesn't pay, it's all right. Whoever pays, you subject them to
That's the disputed, that's not paid. And in the year of 2000, that OTS was cancelled only because they have not paid. But they are saying they have paid.
No, question is.
That is disputed.
There is a judicial recording. We will not.
Division bench order of this.
Yes.
And in the operative portion, paragraph number 5.
Yes.
It has been directed specifically that you are to take a decision under which scheme and regarding the settlement of the loan account of the petitioner.
Yes.
Not only that, you have to give opportunity of hearing to the petitioners. So admittedly, no opportunity has been given. Disposed it of, that is very apparent on the face of the impugned letter that are not been given. And these things which you have stated.
No. You are disputing. You are disputing. It is not paid, and the division bench has recorded that everything is paid. Have you challenged that order?
No. I filed the affidavit.
No. Have you challenged that? This order stands. It holds the field. We can't go beyond that.
That's the submission of the loan council.
Have you filed a review saying that it was not deposited?
That's the submission of the loan council.
You should have filed it.
Yes, I have objected and I have also filed objection here.
Mr. Counsel, it was your submission before the division bench that there is a scheme under 2011 floated. So it is in existence and they can apply and they can avail that benefit. That is how the order has been passed. and they in fact filed the application for settlement of the loan account within the period prescribed, then what has to be done if they file that such application that has been enumerated, that you are to given an opportunity of hearing and to this. So without hearing them, whatever you have observed,
Yes.
if you would have given them chance to have their say, they could have better explained before you.
That's I will take instruction.
I think
What instruction is apparent? What is
The apparent on the face of
It is
the,
apparent on the record.
that
What
you have
is
not
the-
given the
They
opportunity.
have rejected because I filed a contempt, they are not disposing of my application. After contempt notice was issued, they rejected.
They rejected it.
No, that's payment on their part. That's delayed. That's
But what, that was not the ground of rejection. Your
No,
ground,
no,
none of the three grounds you have given, you have not said that the amount was not made. Even in the rejection letter, you have not said.
rejection as per the OTS terms and conditions.
Now, where have you said that the amount is not paid?
Yes, I filed the affidavit.
No, affidavit will not supplement that order. The order must take itself.
Filed affidavit before this honorable court disputing the same.
ଆପଣ order ହିଁ କିଛି ଲେଖିବେନି, that is the main, the order which is challenged.
Yes, madam.
We have to see that what was required to be done by you as per the division bench order and what you have done.
As per 2011 scheme, on the ground of malfeasance, it has been rejected.
So you take the decision on your own. Why the line was mentioned there that you are to give an opportunity? Because they could have explained before you.
I want my short time, 1 day or 2 days, I will take instruction for the opportunity within of us.
Monday.
He said we want to see it next week.
Monday.
Mr. Mishra, is it your contention that you stand that no opportunity has been provided?
No opportunity.
All right, we are
So
just.
one thing I would like to bring your notice, that they have not stated anywhere in the counter that opportunity was given. Number one. Number two, that's the reason of rejection. Kindly look at their counter, their written note. Their written note.
Which page, Mr. Mishra?
The paragraph, page 3, paragraph 4.
Yes.
Sorry, paragraph 2 at page 3, page 2, page 2. They are referring to a Supreme Court decision on which ground they can reject the OTS. Supreme Court has clarified it. Page 2, top part. If the bank or financial institution is of the opinion that the loanee has the capacity to make the
Look, where are you reading? We are not getting.
page 2,
If
the Supreme Court decision.
That starts in paragraph number 10. If a prayer is entertained.
Right.
You are right, rightly reading.
If the prayer is right.
Rightly reading, yes.
So that having quoted, the para 11 continuation next.
Yes.
OTS proposal on which ground can be rejected. If the bank financial institution is the opinion that the loanee has the capacity to make the payment and or the bank financial institution is able to recover the entire amount even by auctioning the mortgage property or secure property.
You are reading para 10 now?
Para 11.
The portion which you have reproduced, you are reading.
Yes.
If a prayer of entertaining of the part of the defaulting amount, that you are reading what?
You are reading that.
If the prayer that starts from
written note of submission.
Para 11.
Written note of submission filed by the opposite party.
Yes.
You are placing that written note of submission or
Yes.
counter affidavit.
Nice, a written note of submission. Item 2, para 2.
Para 2.
Sub para 11.
11. A sum and substance of the aforesaid.
No.
Will be that.
One time issued by the High Court, it is the power of so-and-so, direct financial institution that to positively grant the benefit of so-and-so. The grant of benefit under OTS is always subject to eligibility criteria mentioned in the OTS scheme. The guideline issued from time to time. I got it?
Yes. If the bank and financial
institution is of the opinion that
the loanee has the capacity.
Yes, has the capacity to make the payment and the loanee financial institution is able to recover the entire amount even by auctioning.
Continue.
Thank you.
The loanee.
Okay.
Yes.
So that is the reason for which actually it can be rejected.
Let us read once again. If the loanee has the capacity to make the payment and or that the bank and financial institution is able to recover the entire loan amount even on the action of both the mortgage property or
Either from the loanee and the
either from the
guarantor.
loan
Bank would be
also when there
refusing, sir.
would be
This
justified in
refusal is-
refusing.
This refusal is not on this ground. Refusal is not on this ground. There's a malfeasance, misfeasance, which is not available to be taken.
Let him come next.
Okay, let him.
And sir, our decision will take this to 2012 Orissa phase 48. And there are Supreme Court decision which says.
You have already annexed with.
Yes, sir, I have given that. The note.
Para?
The paragraph 6 and 7.
Yes. OT scheme. Yes. Oh.
It is further stated that OTS scheme, namely MDF OTS 7, was introduced in May 2009. The corporation released several advertisements on the website of the corporation. The last date of receipt of valid application of the OTS scheme duly supported with required processing charge, initial deposit. So the petitioner was advised by the corporation about deposit of 3,000 as processing fee, 1,07,000 as initial deposit. And otherwise, the application will not be valid application. There is no obligation to part of the corporation to consent. Undisputed, the petitioner deposited 2,724 and 1,07,000 towards processing fee, initial deposit respectively, 12/12/2009 beyond the period which was stipulated. Therefore, there is no obligation to part of the corporation to consider the applications for grant the benefit of PSK. As the question of resolution of writ of mandamus doesn't arise, the petition application can be considered only on OTS scheme policy 2011, which has come into force in 2/5/2011. The said application will be considered against the scheme as per terms and conditions stipulated in clause 6.2 of the claim statement. Formula will be given in the said clause. Further reliance has been placed on clause paragraph 12 of the counter affidavit when claim of petitioner made in paragraph 14-15 is traverse inter alia, containing the petitioner is a chronic defaulter, which is evident from the default position of the principal and interest amount in total 85,01,272 are outstanding against that. The OTS proposal of the petition has been rejected by the corporation due to malfeasance, which was communicated to the petitioner 12/12/2010. It is open to the petitioner to apply against 2011 scheme by submitting valid application in terms of the guidelines stipulated therein. The same will be considered again the said scheme. In fact, for non-compliance, the interim order passed by this court on so and so day, this court vacated the interim order passed on so and so. The above order of the court has been made clear that petitioner was defaulted and did not comply with the interim order of the court. All the chance was given for it to it is the duty of the corporation to obey the direction of the court and to realize the loan amount. The opposite party corporation cannot discriminate other entrepreneur by adopting a separate principle of OTS and the petitioner by agreeing with the demand of the petitioner. According to the stand taken of the petition and the allegation made against the corporation, the writ petition not based upon fact and the same is denied, false. According to the corporation on 31/10/2010, total outstanding amount due against the petitioner is 1,41,31,37,000. Such being the factual position, petitioner not entitled to relief as paid from the writ petition. Petitioner approached the court by filing a writ without complying with the initial direction of deposit of 30 lakhs. Therefore, the corporation prayed for dismissal. Petitioner also filed a memo enclosing therein the total loan amount along with the calculation interest of the date of disbursement of the cutoff date on 31/3/2003. According to the petitioner, payment made on 81/2/2010 is 3,92,000 so and so. There was cash, check, and demand draft. The sanctioned amount of 11,64,000 by different sanction order has been mentioned in the calculation sheet. Disbursement amount has been made to the date on OTS 7 scheme would be 11,60,000. Total interest of principal amount is 11,60,000. That is 14,81,000 somewhat. Total amount outstanding due to corporation is 26,46,043,505. Repayment by the petitioner is so and so. So according to the petitioner, OTS amount of 2007 scheme is 22,50,539. Since 31 years have already elapsed, WD cost of the client in this is almost zero. On 25/5/2011, the counsel of both parties were directed to file a memo of calculation according to OTS 7. On 28/7/2011, the counsel petitioner filed memo of calculation as per OTS 7 scheme. After filing the memo, the counsel of the petitioner along with the calculations regarding the outstanding amount of OTS 2007 scheme. Counsel for the appealing to the corporation were directed on 28/11 to file memo calculation according to the OTS 2007 scheme of the corporation on the basis of the principle laid down by the Apex Court in Central Bank of India.
Yes, what do you want to say out of all this?
There, the court has directed 2007 OTS scheme has to be followed.
Yes, in the ultimate paragraph it says,
Yes.
penultimate paragraph.
Next paragraph.
Delay was 1 year,
Para 10.
and they say that.
No, para 10.
Para 10, yes.
We have already held that rejection of the application for one-time settlement under OTS 7 scheme is
On technical ground.
is bad in law.
Technical, bad law.
Page 10, Malad.
Yes.
Though the corporation has
accepted
accepted
it.
GD which were received by them belatedly on 12/12/2009 towards process fee and initial deposit for considering OTS 7 application submitted by the petitioner, since we have passed the rejection order of the application for rejection recording by the answering point number 1, we are of the view that we are having regard to the facts and circumstances of the case, OTS 7 application filed by the petitioner will be considered by the corporation the terms and conditions stipulated therein. As per the calculations submitted by the learned senior counsel, the total outstanding amount to be paid to the petitioner corporation was such an amount. So the demand raised by the corporation much more, which is arbitrary and unreasonable. Therefore, we direct corporation to consider OTS 7 application already filed with the petitioner and dispose of it.
But let him. But your stand is 2011 scheme and account up till 2019 from the date of rejection.
Right. And my 2021. There are about 2 crores, more than 2.5 crores is there with them, which they have kept in separate account in a fixed deposit. The rent collected by them, which belongs to me, they have to refund to me.
Since
that will be that is a calculation issue.
Since 29/4/2001, the tenant is not paying the rent, and the IA has been filed before this honorable court for stopping of the payment. Before passing any order, that payment has been stopped. And on 26/2024, this honorable court was also issued notice to the tenant. Tenant is not appearing, not also paying any amount till date, and not complying the order of this honorable court.
The order has been complied with.
That's a different cause of action altogether.
This is the interim order here, my lord.
Why should we will be a collecting agent from the tenant?
That's the order of this court, my lord.
Sir, pay 68 percent.
This is something different, and you are doing on different.
You brought up your disputes here to the court. We'll keep on collecting rent and all.
Lords, my lord, that's this honorable court's order, which has not been complied.
This is not the scope of.
Number of times the interim order.
All right. The writ petition has been filed by so and so, challenging the later dated 13/8/2019, the annexure 21, issued by the branch manager, OSFC, in rejecting the OTS proposal on the ground of malfeasance and willful default as per the policy parameters of OTS 2011 scheme. And mentioning therein that the outstanding loan account as on 17/4/2019 is rupees so and so, it is 1 crore so and so. Mr. Mishra and senior advocate submitted that last time when the matter was before this court in WPC number 24068 of 2017, where the petitioners challenge the notice of the OSFC dated 13/10/2017, demanding an outstanding dues of rupees 1,20,85,734.19 within 30 days, failing which the corporation is to sell the mortgage property to the prospective buyers through public auction. This court disposed of the writ petition as per the order dated 28/2019. And in the operative portion of the order, it appears that the London Council appearing for the OSFC made a submission before the division bench of this court that one-time settlement scheme has been floated in 2011, which was still in existence, and it was open to the petitioner company to avail such benefit if they are so advised. And it was further observed while disposing of the writ petition that in case the petitioners file an application to settle the loan account within a period of 2 weeks from the date of passing of the order, in such event, the OSFC shall consider the same as per 2011 scheme and take a decision expeditiously, giving opportunity of hearing to the petitioners. A further direction was passed, order was passed to continue the interim order dated 29/11/2017 till the decision was taken by the Tribunal regarding settlement of the loan account by the petitioners. Pointing out the impugned order later dated 13/8/2019 under Annexure 21, the Land Council submitted that even though as per the order passed by this court under Annexure 15, which is dated 28/2019, the petitioner filed the application for settlement of the loan account under OTS 2011 scheme, but no opportunity of hearing was provided to the petitioner, flouting the orders of this court, and it was rejected on the ground of malfeasance and willful default of the policy parameters of OTS 2011 scheme.
The content was.
And particularly when it is submitted that this order was passed mainly because the petitioner filed a contempt petition before this court for non-compliance of the order dated 28/2019. The Land Council appearing for the OSFC, when questioned about the giving opportunity of hearing to the petitioners as per the order of this court dated 28/2019, it takes some time till next week to obtain specific instruction in that matter. The Land Council for the petitioner placed the citation, the decision of this court in case of Premier Sit versus OSFC reported in 2011, SCC Online 388.
SCC online.
SCC 2011 SCC Online, Orissa 388, and submitted that in view of the conduct of the petitioner in complying with depositing the amount, the interest, etc., as per the latest of the opposite parties, it cannot be said that the petitioner is a willful defaulter, and therefore the rejection of the OTS proposal on the ground of malfeasance is not sustainable in the eye of law. This matter. The put up this matter on such and such date. The Land Council for the OSFC shall not only obtain instruction regarding providing of opportunity of hearing to the petitioners while issuing the letters, while disposing of the OTS proposal, but also obtain instruction as to whether, as for the OTS proposal, OTS scheme of the year 2011, they are ready and willing to settle the loan account of the petitioner up to that, what is that period? From
2019
up to 2019. Hello? The state on Tuesday, we'll keep it on 8th of 8th of, what do you say? 8th July 2025. Yes. Good. Interim model.
That is not complied with. That's the intermediate not complied.
Already,
And the tenant is in the notice has been issued, and tenant is not actually.
Tenant is not a party to this property.
Param-
Tenant is a party to this property.
Yes.
Included.
Yes.
Sir, the order was, till you take a final decision, they'll
Who
depose.
is appearing for tenant? Nobody is appearing.
No, he is not appearing, not also
Hey,
complaining.
neither
The
paying
interim
or
order.
not paying there.
And the
And
interim
a separate cause of
order
action.
number of times.
Yes, next.
Item 11.
But item 11, my learned friend will pay the same, but I want that this WPC number 33098 of 2023, that was filed on the self-same pair. Thereafter, they added some pair and filed the same. So let both the case will take up together. That is a disposal case 33098 of 2023.
Mr.
An order was
Pari, we
passed.
are taking of item number 11.
Yes, in that 11, there is another case which was filed by the self-same petitioner, and order was passed on 18/10/2000 on the self-same prayer.
What is the number?
33098 of 2023.
3098 of
2023.
23.
Yes, and it was disposed of on 18/10/2023.
Disposed of? On
Yes, ma'am. 18/10/2023.
18/10/2023.
Yes, my lord. I obtain the liberty, the honorable director to approach the CAT again, because my contract petition was dropped in my absence.
But order
No,
is
that is not the issue. What Mr. Pari is pointing out, if on the self-same issue, prior to filing of this writ petition, you have filed another petition and it was disposed of, are you not supposed to?
No, my lord, not self-same issue. A contact, at the admission stage, when the lordship was passing the order.
You have mentioned that this matter was never before this court in any form whatsoever. Please see paragraph, page number 4. How can you say that the matter out of which this writ petition was never before this court, whether that was just some other matter?
Well,
it may be that the issue is little different, but can you say that the matter out of which you were never before this court? Are you disputing that you have earlier approached this court in this writ petition? Then, so that is how he say that. Have you got a copy of that order?
18/10/2023 order in the earlier writ petition. Do you have that copy?
And have you got the writ petition copy also with you? What was the prayer made in that writ petition?
Same prayer. The prayer made in this writ petition and
So that writ has not come, that writ petition has not come.
the
We are
same
calling
praying
for
by the
that.
Lordship may take up both the
Lemon.
writs.
Mr. Pari, Land and Count Deputy Solicitor General submits that the petitioner earlier approached this court in WPC number 33098 of
Yes, yes, ma'am.
2023,
Yes.
which was disposed of on 18/10/2023, and the very same prayer which is made in this writ petition was also made in the aforesaid writ petition. However, the petitioner has mentioned
In the preliminary objection, in para 70, they have written it. They have written it. That they humbly submitted that petitioner also has previously sought similarly in writ
and
petition also.
and that the
That is-
petitioner in his writ petition in paragraph
No,
number
not repetition. In
No?
the objection by the
Acha.
respondent.
Okay.
In our
And,
counter, we have reflected
Acha,
it.
in the counter affidavit,
Para 70.
also it has been highlighted by the opposite parties in paragraph number
17. 17.
17 that previously the petitioner sought for similar relief in WPC number so and so, which was dismissed by this court on 18/10/2023, and the petitioner has not mentioned anywhere in the writ petition about filing of such writ petition earlier before this court, and therefore the records of WPC number 33098 of 2023 be placed for consideration with this writ petition. Stop. List this matter in the week commencing from 14th of July 2024. Acha, lekhundu. On a we find that in page number 4 of this writ petition, it has been mentioned that the matter out of which the inverted comma this writ petition arises was never before this honorable court in this form whatsoever as per the instruction of my client, inverted commands. Put up this matter in the week
And
commencing.
in the rejoinder also, he has not disputed it. By the rejoinder.
It is also pertinent to note that even though the petitioner has filed a rejoinder affidavit to the counter filed by the opposite party, the averments taken by the opposite party relating to the filing of the earlier writ petition has also not been disputed. Put up this matter in the week commencing from 14th of July 2025 with WPC number 33098 of 2023, stated to be disposed of on 18/10/2023.
May I pray? इसी ऑर्डरटा मु क्या को
आसु
जाइनथि ऑर्डरटा आसिला
देखिवा कागज पत्र
एई कथाटा को से माने रेलवे बोर्ड मो फेवर ऑर्डर कर इंप्लीमेंट करिया पई ये माने माइलट दिस सीजीसी
let it come. Mr. Mahanti, let it come, we'll verify.
See, we'll see that.
Railway board is in my favor.
You will get opportunity to explain. Don't worry. Let it come.
Only mistake must certificate लिखो.
We are just coming within 2 minutes. All right.
I confess.
Item 30.
What is the matter, Mr.
The auction date tomorrow, Mana. This was the first the Vanaspati Ghee factory which was set up in Orissa.
Oh, which for the other side?
Mr. Amitabh Das, senior advocate, OSFC.
So when you are making a mention and want us to take up, just intimate him.
I'll
Because he might be seeing that it is the item number.
just,
Let him come and Yes.
I'll call him.
call the matter
I'll
serious.
call.
Item 13.
12.
12 tak hona lagi?
Item 12.
Well, Mr. Pari was saying something.
Yes, in 12, item 12, Mr. Kashyap is appearing this case with me. It's a case last occasion, my learned friend is cited after the two decisions of the Supreme Court. But this complete decision, they said two decisions is completely square of our case because it is a case from, there is a pendency of CBI matter before the trial court, before the CBI court from 8 to 2014. It is admitted. Their claim is that as you have not taken an initiative charge against us, it is a case of trap. Now he is superannuated. Only financial claim can be made in this regard because there is no, he is already superannuated in this case. But cross of the issue is that from 8 to 2014, when the matter is sub judice for a trial, department could not proceed against him. After filing charge sheet, department proceeded in 2014. This is the only
Mr. Pari, just a minute. So, counter affidavit has been filed by,
Yes.
you have filed the counter affidavit. So, anything you want to say or we'll hear the matter?
Yes, sir, only one point I am telling. Suppose my lordship allow or disallow, whatever may be. Now, till date, the CBI court has pending, the trial is going on, it was not concluded. Suppose any adversarial pass, if you will pay money, how it will recover? This is another question. And Supreme Court said, one way helping the petitioner by two decisions. Other, the same Supreme Court says, in the trap case, it is the stringent view will be taken by the court in this case. We are in dilemma. This is the issue my lord might adjudicate in this issue. I apprise Mr. Kashyap to assist the court only in all respects.
Yes, sir. Argue.
My lord permits, then because what my lord senior has already pointed out, I can jot down those points and I can bring it before this honorable court.
Yeah.
Because the whole issue is.
Now come to the date chart.
Lordship.
Counter phase 8. Can give you adjust breakfast. Counter phase 8.
Okay. You place any of your place. You want to place 8?
8.
Okay.
Phase 8 of the counter, that is the date chart.
Place from none.
On
Lordship.
Yes.
Please read it.
Lordship, on 12/11/2008, a trap of CBI was conducted and this opposite party was caught red-handed and a strong prima facie case was instituted against the opposite party.
He was accepting bribe.
Yes.
What was he? What was he?
He was then he was the Deputy Commissioner of Central Excise and Customs,
Achha.
posted at Calcutta.
What is the amount?
1 lakh. 3 lakhs he has demanded, but 1 lakh was recovered.
Okay.
That is the finding of the disciplinary authority, as well as it has been never disputed.
Okay.
And the proceeding is pending.
That FIR was lodged against him.
FIR was lodged against him.
Yeah.
In 2013, my lord, the DPC was held for promotion from the post of Deputy Commissioner to the Joint Commissioner. And in the DPC, he was found fit, as per the report of the DPC. And accordingly, DPC sought for information from Vigilance Department, and Vigilance Department intimated that there is a CBI case pending against him. It is under investigation. And on 8/1/2000, here you'll see one thing has not been reiterated in this date chart, that is 13/12/2013, the DPC was conducted and he was found fit. On 6/1/2024, he came before the Honorable High Court of Calcutta and challenged the order of taking cognizance of filing of the FIR and filed for quashing of the FIR. And accordingly, the matter was stayed, that is pending before the CBI was stayed. And from 6/1/2014 till 2016, December 2016, the stay order continued. Initially, the stay order was granted for 5 weeks.
That is not mentioned here.
Here it is not mentioned. That's why I was saying that
I am telling that don't omit and such dates.
No, it is there. It is there in the impugned order that is challenged before the Tribunal.
In the date chart, he said that it is exhaustive one.
No, that's why I was saying that the question that has been already put forth, my lord gives only 3 days time. I can
prepare
date chart. That will certainly help our
relevant thing.
Yes,
because if they
that is all on record, but it has not been come up.
No, what to?
His promotion, his DPC result is put in sealed cover.
It has been
sealed cover procedure has been followed.
Yes, it was put in sealed cover. In the meantime, pursuant to direction of the Honorable Tribunal, twice his case has been considered, but in the meantime he retired. By the time the interim order could be vacated, he retired in 31/7/2015, and that is his case. That because for the investigation under process, I retired, so I should be promoted notionally and the financial benefit should be given to me. So here I have to distinguish the Harsh Kumar case.
The London Council for the petitioners submitted that though earlier a date chart was filed on their behalf, and also a date chart is there in the counter filed by the opposite party, but some dates are missing. Some important dates are missing, and therefore he may be given some time to file a fresh date chart. Put up this matter on such and such date.
You file an exhaustive
for filing an exhaustive date chart.
Yes, yes, we'll file.
Only fact I can let know one sentence now. On
No, you see, as such, there is no urgency now. You have already retired, and if you get, ultimately you will get it. What is there? Yes.
The paper DPC, there is no asset in this.
Okay, that is.
Item 13.
Next date.
You will fix the date. Yes.
And item 13 that the order of the tribunal has been challenged before my lordship.
We seek time to file the counter. We're ready with counter by next week.
In which case, item 13?
13. We'll file the counter.
The petitioner is not getting a single pass, then bed ready.
Yes, we include everybody by name, then again file everything is okay. We'll file by within.
Mr. Parhi, London Deputy Solicitor General, appearing with Mr. Buchai.
Kaibalya Panda is physically there.
अच्छा Kaibalya Panda अपन को ये टा दीजिए Central Government Council के
yeah, CGC.
So his D. Buchai's name will not be reflected in the. All right. Seek some further time to file the counter affidavit. Place this matter on such and such date. the name of so and so central government council be reflected in the this order, so also in the onwards like in place of Mr. D. Goshayat CGC. Yes.
Item 13.
Item 14, may please, my lords.
If 14 also will be reduced, the counter will file within 10 days.
Lordship, may kindly look into the order dated 21st January 2025. Lordship has been directing the opposite party to file counter, but they have not filed the counter yet. Lordship may fix a
Within 7 days, we will file.
Mr. Pari, whose name will be reflected with you.
Guchayat, Mr. Guchayat.
Guchayat Punalagam. So and so appearing with Mr. Guchayat CGC. Take some further time. Put another date for filing the counter affidavit. Yes.
Grateful minutes.
Item 15.
In view of the order of Ombudsman, Annexure 7 at page 59, and the proceedings pending before the regulatory commission, that is also challenge for this Honorable Court, on the ground that the Ombudsman, while passing the interim order, he has not delivered, there is no deliberation there with regard to limitation point that we have raised before the Ombudsman. And on the basis of the calculation sheet that was produced and without providing opportunity to us, the interim order was passed. The Lordship kindly have page 75, the order of Ombudsman. Relevant
27/6/23 under Annexure 7.
Annexure 7. May I draw your Lordship's kind attention to page 75.
Yes.
No, just go to the top. Just let us little factual. Then
Factual,
we'll come to
your Lordship,
just go
the
first page of the order.
I am submitting, Lordship, the opposite party
Why are you not placing that? Just we want the first paragraph.
during the different dates of hearings.
No, leave that. He has challenged the order dated so and so. Then you being aggrieved, he has come. In this regard, as it will be put on. Yes.
Being agreed by the aforesaid order of the GRA, the petitioner has filed this case before the authority for redressal of his grievances.
In this regard.
In this regard, the petitioner challenges the legality, validity, and propriety of the action taken by the opposite party in issuing revised demand notice, filed as office letter number 2860 dated 21/4/2017, relating to the period of November 14 to January 16, demanding 1,02,04,994.34, and the consequential threatening letter number dated 6/5/2017 to destroy the power supply without further notice in the event of failure to pay the demand. On the ground, inter alia, that the said notices are illegal and arbitrary. The action of the opposite party are illegal, arbitrary, and contrary to the provision of Indian University Act 2003 and OERC Distribution Condition Supply Code 2004. The petitioner is a private limited company having its office at Bhariamal Chowk, Bargaon and district of Sundargarh. The directors of the complainant's company are citizen of India and a residents of Odisha. The opposite party.
Now you come to the page number 65.
Miller.
Page number 65, the third subparagraph.
On bare reading of the facts narrated above, would go to establish that the petition is a small-scale industrial unit and categorized as a large company. The petitioner has made payment of energy charges as per the demand raised by the opposite party on monthly basis. The petitioner has availed power from Indian Energy Exchange on the consent of the opposite party. The petitioner has also paid the charges as per the statutory requirement as charged by the WESCO for the power availed by the petitioner from Indian Energy Exchange. The present demand has been made by the opposite party on the ground additional bill is on account of HT loss, high tension loss,
which was not included in the pleas. The opposite party by letter dated such and such, dated 5/5/2017, has admitted that the revision of cross-subsidy surcharge bill data has been forwarded to SLDC from the head office for on and be made certain. The petitioner states that it is obligatory on the part of the opposite parties to set up the cross-subsidy surcharge received by them against the demand raised by the consumers. In other words, the cross-subsidy surcharge is to be adjusted against the additional claim. Once it is attended, the claim amount would reduce substantially.
Okay, now you come to the paragraph which you are placing.
Your Lordship, page 75.
75, yes.
Before that, I will clarify one thing, Your Lordship.
Yeah.
That issue involved in the present petition with regard to the open access consumption of the power supply. The opposite party, he availed the short-term open access from the Indian Energy Exchange, where the state load dispatch center is the nodal agency. I may draw your Lordship attention. Kindly have a glance. What is the open access related issues, and that has been regulated by the regulator.
पेज नंबर कितने ये वही दर्शन दी कितना नंबर पेज
This is the book. That is page 649. That is that.
What is the commission determinations of open access?
Difference of open access charges, regulation 2006. Lordship, at a glance, definition 2I, 2 Roman I, the nodal agency. Nodal agency means nodal agency as specified in regulation 7 OERC terms and condition open access regulation 2005. The nodal agency under the regulation 2005 is state load dispatch center units.
State load dispatch center.
SLDC. Because I am giving the 2005 regulation that is notified. You will also kind of glance. That is 2005 regulation. There is two type of open access. One is short term and one is long term. Let's see regulation 7 at page 3. That is Orissa Election Regulatory Commission terms and condition of open access regulation 2005. Seven university, the page 3, regulation 7, that defines the who is nodal agency.
State load dispatch center.
Nodal agency for arranging long-term open access shall be STU, that state transmission utility. If the transmission, that is for long term, here is the case is short term also, clause 2. For short term open access transaction, the nodal agency for receiving and processing application shall be the state load dispatch center, SLDC. The SLDC shall, however, allow short-term open access transaction only after consulting concerned transmission disposal in certain service. Then you will also kindly glance page 9. The procedure for short-term open customer.
Page 9 money footer.
Page 9 of 2005 regulations that I have given you.
The one which was given.
That That is the 2005 open access regulation. Page 9, the clause 2, your lordship, procedure of short-term customer. The short-term customer shall submit an application for transmission distribution access to the SLDC. That means SLDC is the nodal agency on which he will file an application, he will approve all these things. The SLDC is managing the entire open access supply power to his units. Then your lordship can level glance. What are the charges the open access customer that paid to the license? That is, once he is paid the cost of surcharge, and another is the transmission distribution loss. That is clause 6 says, your lordship. That book, your lordship, that book, page 656. In the book, your lordship, that 2006 regulation.
Energy loss.
Energy loss. That is the energy loss is to bear and the cross subsidy surcharge. He availed
Read it.
The energy losses, the transmission of the distribution customers seeking open access shall bear the average technical loss in the transmission distribution systems respectively as estimated by the SLDC. The energy losses in the transmission distribution system shall be compensated by additional injection at the injection points. The transmission distribution loss as approved by commission for the previous financial year, along with such and such. My submission, he availed the open access, short-term open access from Indian Energy Exchange on the application approved by the SLDC for the period November 2014 to January 2016. That we inadvertently, the distribution loss that was not raised, that was not claimed from that was a claim. The additional bill was raised as per SLDC approval, Annexure 1, on 21/4/2017. That is 1,02,04,994.8535 questions. And for non-payment of the same, a disconnection notice was issued. That was challenged before the Tribunal Court in WPC number 9262 of 2017. This Honorable Court expertly directed that since the matter pertaining to the GRF, Grievance Redressal Forum, alternative remedy is there, then you approach to the GRF and GRF will consider. Subsequently, what happened? They did not approach to the GRF. They paid that amount to us without any protest. Subsequently, they filed a GRF, they moved to the GRF, the Grievance Redressal Forum, after lapse of 4 years. Filed an application before the Ombudsman initially on the plea that their application was not considered by the Grievance Redressal Forum and no order has been passed. That was not correct. On the plea, they moved to the Ombudsman. Ombudsman, without noticing us also, that was remanded back the matter to GRF for adjudication. GRF GRF rejected their application. Category held that no such application was pending before the GRF as they had taken the plea.
What was the claim in the application?
Claim application that after payment of that additional bill of 1 crore such odd amount, they claim they are not entitled to pay that amount to the licensee in view of section 56(2) of Electricity Act 2003. 56(2) says there is a limited of 2 years for demanding that amount. But however, Supreme Court Honorable Appellate Court in the Ramtola case, so Prem Patek's case, that GRF dealt with the same, held that licensee can demand when the due accrues. GRF, considering the same, rejected their application. Your Lordship, kindly glance the finding of the GRF. That is page 35. Page 35. Finding of the GRF. The second paragraph, Your Lordship. during the course of hearing, the quorum requested the petitioner to provide
1 minute. 1 minute.
Suppose you are the distribution license, right? He had taken, he was a consumer, this, and
OP1 is the consumer.
right. So OP1 is the consumer, and you are the distribution licensee, and then he applied to you for this open to be a open access consumer.
He applied to the SLDC, State Load Dispatch Center, to allow file an application there to allow him to avail the open access power.
Right. So that is to be permitted by the state commission, and accordingly he was permitted also.
Yes.
He availed the same.
Yes. He availed the same.
Now the question of that
the distribution loss that he has to pay, that could not be inadequately demanded, that was subsequently demanded.
Distribution loss means
that the open access consumer, he availed the power from our network, our supply network.
Lordship, allow me, I just put it in.
He availed the Indian Energy Exchange is a.
No,
contesting. I'm just fact saying that a consumer can avail power from two sources. One is from the distribution licensee or DISCOM. The other one he can import. To import, there are two methods. One is long-term import and short-term import. See, that import is routed through that SLDC, State Load Dispatch Center. So
insofar as short term.
Yes. Once I'm importing it, the importer will drop the power at the DISCOM border. DISCOM border. So now that power is to be wheeling through the DISCOM line and will be made available at my factory or whatever end. So under the OERC formulation, that the DISCOM, because the DISCOM is entitled to distribution loss and cross subsidy surcharge. That is, what is that? Now there are four types of consumers. One is farmer, domestic, commercial, and industrial. So since the distribution licenses are selling power at subsidizing rate to the farmer and the domestic supplier, so they are charging that from the commercial and industrial. So since I am buying it out from outside source, I will be not paying. So that is also I am liable to pay. So one is cross subsidy surcharge, the other one is wheeling and distribution loss. So this wheeling and distribution loss has been formulated by the OERC in its law that to be 8%. Now their case is that in 2015, yes, we have availed, because how much I am import is the bill figure says that how much I import and how much they raise, everything is there. They say in 2017, 2 years after, that we have not deducted the distribution loss. So hence, we are now issuing a supplementary bill. Please pay it. Now, this the ombudsman has done, yes, he taken their figure. You have say, suppose 100 unit I am availing, they 92 I will get. So suppose 100 I am importing, 8% loss will be accounted for. So at my end, I can avail 92. But their power is also mixed. So therefore, they have the record of what is the imported unit. They will deduct the 92. Balance is chargeable to them and 92 for that. There are no disputes, my lord. So that 8% is now been recalculated. Nothing, as per their figure, the tribunal, the ombudsman has calculated, you are charging more.
But why have you paid then?
My lord?
You have already paid.
No, I am paying that 8% and the cross subsidy surcharge. That I am obliged to
No,
pay.
cross subsidy you have refunded, but after revision
Huh.
it is refunded.
So I
Once it is paid, therefore refund.
So 8% I have to pay for distribution loss. That they say ki I have they have wrongly and on the threat of disconnection, I make payment. I came back before this honorable court. This honorable court relegate me back to the GRF. So on the threat of disconnection, I paid and I filed a GRF complaint. That remained standstill. They didn't issue. Then I approached the ombudsman. Ombudsman directed to that considered it. Then it was considered and rejected. Hence I filed appeal. And in the appeal, this impugned order has done nothing. It has simply, Lordship can have that impugned order at page. The last table, my lord.
Is
page 75. Kindly see, my lord. This is simple arithmetic has been placed here. Table A. December 14. The power is.
That is,
Just
1 minute. Let me
it is not placing that matter, Lordship.
I'm just showing what is there.
They produced the table before the ombudsman.
Again, it is a matter of calculation.
Yes, that was not provided opportunity to us to counter this.
They have in their rejoinder has today admit that every bit of data shown in the table are up there. They have admitted before this.
That is our, but the scheduling that he is availed the power from the schedule. That is a schedule from the SLDC that you will also calculate 1 hour. That is 4 schedule, 15 minutes schedule. The schedule that has not been calculated here also. The transport not distribute loss.
Are you also aggrieved by the impugned order?
Yes.
Then we will set aside, reconsider.
No, I am not.
Both of you are aggrieved. Then what?
I am not agreeing.
Table that opportunity of hearing was provided to us.
You say that the calculation is wrong.
The calculation has now been held to be adjudicated to be wrong, and it's simple arithmetic. My lord, your lordship kindly see. IX. My lord, just I am trying to. My lord, 20.52. First figure December 14. 8% of it is 1.64. Then 18.88 is net receivable. Now, my lord, total consumption is 3285. 3285 minus 18.88 is 3266 is chargeable. Chargeable. They have revised to 3267.5. So the tribunal said
that's
0. That's your bill. Absolutely nothing is there here for SLDC cause or simply they have calculated arithmetical error has been corrected. 8%, Lordship, I am drawing your Lordship's attention to that their letter of dated 21/4/2017. What is the premises? The premises is that they have missed. Your Lordship at Annexure 1, page 21.
No, Mr. Ratho, what he is pointing out that this table, which has been, you are now placing that table in page number 75 or internal page is 17, which was produced by you. This was produced by you. The language has been used.
Yes, my lord.
The table has been produced by the petition.
Yes.
You cannot dispute it.
No, I am not disputing.
So once the table is produced by you, whether this table also the copy has been given to him and they have been given an opportunity to have their say on this, or you say that according to you it is an arithmetical calculation.
No, my lord, I'm just answering to it. It is being given to them. On this count, they have filed a review and review has been dismissed. Number one. Number two is, my lord, the data which is there, they now admit in their rejoinder that all of their data, nothing has been brought from outside.
No, not
so the principle of
he disputes that.
I'm drawing your lordship to rejoinder affidavit.
Your lordship,
I'm drawing your lordship attention to the rejoinder.
To the point that your lordship pertinently asked a particular question to my friend. He did not answer it himself.
That table that has been taken into account.
Whatever table you have given, they have accepted the pass the order.
Milord.
Without giving them. That's their, that's his case.
That is exactly his case is that.
Any read jurisdiction, will you, we will go into all this calculation business?
No, I am not saying.
Question,
I'm not saying.
question
The
is
question
that
here is that
they now if you say that this table with the calculation sheet, let us say this is a calculation sheet, it has been provided to by you and it has been relied upon by the authority concerned. So an opportunity should have been given to them to have their say on this table. That has not been given, but you say that in the rejoinder affidavit.
yes, my lord,
So where is that rejoinder?
rejoinder affidavit is there in the other matter. The
No,
lordship,
no, this matter, Lordship.
29
That rejoinder is there, Lordship.
yes, ma'am.
The rejoinder is there.
At page 162.
Rejoinder affidavit filed by the petitioner.
At page 162. Page petition is there. May I just place, my lord?
Running page 6.
Running page 6 is.
Milord, paragraph 9, Lordship.
Yeah.
That as regards calculation of open access power and determination of distribution loss as referred by the learned ombudsman in table A of the impugn order, it is submitted that table A reflects the month-wise drawal of total power, month-wise total power to open access and from the discounts. The quantum of open access power, the quantum of power after deducting distribution loss. Though the figure mentioned in the said table have been derived from the additional bill.
Yes.
Raised by the licensee for the subject period, but the calculation distribution loss and drawal of open access has been done in an incorrect manner. As per the open access mechanism, the open access power is being scheduled on the basis of 15 minutes integration period, and as such, the distribution loss of 8% is normally calculated on the open access schedule in every 15 minutes block. The petitioner has provided the said table A by making erroneous calculation of open access charges after deducting distribution loss by an ombudsman to without verifying the method of calculation of open access power and distribution loss has adopted the said table A, which reflects non-application.
That is the exactly.
That is the exact point.
My answer is this. What they are not disputing is the data.
No, this calculation.
Calculation is
Calculation. No, what they are not disputing is data. I am not saying calculation.
Question is that if they would have been given the opportunity, they would have all brought all these matters before the and that could have been considered. That whether your table is correct or the thing which they are presenting is correct.
I am fully agree with that. That's what I am answering.
We will remand it.
I am not. I am answering. I am not.
Application that are not considered.
I am just answering, my lord. The lordship may do away with the calculation part of the table. It also have the data. Now when you read this, the data they are accepting.
No, we are not. That is relied upon and the impugn order was passed. So how can we do away with it?
My lord, I am not. I am just arguing, my lord, to my
particular order has been passed, relying upon a table, and that was produced by you. How can we ignore the table?
Man, the principle of natural justice say if the constitution would not materially change the decision, then it is not required.
Whether it will materially affect or not.
The question of that 15 minute slot, even today they have not produced any document to that effect. How
we are not here
the review on that ground, my lord, I say that we have given it.
The preceding the table, you read the sentence. The table produced by the petitioner given below is showing so and so.
That copy has given.
And thereafter, the end, what it says, from the analysis of the table A, this authority safely conclude that the entire calculation of revised bill raised by the respondents are unsustainable like that. No analysis done.
My lord,
that upon your lordship, we file a review application. That is
yes, my lord. Review also they have setting that it has not given.
We will remand it.
Review.
All right. This writ petition has been.
I'll have to make my submission.
Executive engineer challenging the order dated so and so. And the impugn order, it appears that the learned ombudsman 2 has relied upon a table which was produced by the petitioner showing that the license is claiming more than 8% loss in their HT bracket 33 kV net worth. And the Lennon Swanso, analyzing that table, has came to the conclusion that the entire calculation of revised bill raised by the respondent, bracket exempt to writ petitioner, are unsustainable in the eye of law, and hence the bills are to be revised as per the calculation sheet produced by the petitioner. The Lennon Counsel for the petitioner has filed the rejoinder affidavit, wherein it is stated in paragraph 9 as follows, for the entire paragraph 9. From the impugned order, so also from the rejoinder affidavit in paragraph number 9, it appears that the said table of calculation has not been provided to the petitioners to have their say.
Well, I'm contesting that because
which is disputed, of course, by the Lennon Counsel for the
review on that ground has also been dismissed.
He further submits that a review petition was filed by the petitioner before so and so, and it was also dismissed. Nothing has been in the impugned order. There is nothing that the table which was produced by the petitioner regarding claiming of more than 8% loss has been handed over to the petitioners, and they were given opportunity of to have their say on this table. The Lennon Counsel for the opposite party submits that even if opportunity would have been provided, the result would have been same. We are not agreeable to such submission made by the Lennon Counsel for the opposite party. Therefore, we are of the view that the impugned order is not sustainable in the eye of law, and we remand the matter to the matter be considered afresh, and the petitioners shall be given an opportunity to have their say on this table, which is mentioned in the page number 17 of the impugned order, and a fresh adjudication to be made on the issue involved. Accordingly, the writ petition is allowed and the matter is remanded for fresh adjudication. Yes,
That limitation point also we have raised, that was not considered.
It is open to the petitioner to raise all the points and including the limitation in
open to both the parties.
And the same shall be considered in accordance with.
Let's kindly have this judgment at least to do.
Relevant paragraph quote kar debe, hai na? What is this connected matter?
That is same.
Same, my lord.
Same.
The same order gives.
Same order mane it out gote piye na kon.
That another entity, but issue involved also same.
Acha se jo Bajrang Bali so and so
same issue, everything is same.
Everything is
same. Paragraph goda ka same thela. Ye jo ame jo quote kolu jo order ta tadri table
Miller.
Paragraph tikhe gote tote jo dekhi debe page number to ache table jo ka say page ro chi
Subsequent page.
not. All right, next.
Oblige.
Yes, Mr. Pali.
Item 6.
Mr. Das is here.
Yes.
He made a mention, but you are not there, so that's why we asked him to just continue. Yeah.
The unit minutes has been scheduled to be auctioned on 5th. This is the first minute Vanaspati Ghee Factory in the statement. Incidentally, the original loan amount was hardly 30 lakhs and the interest standing was hardly 6 lakhs. On the date of seizure, it was a running loan. Over the course of time, it has been run down to the ground. They gave an offer in 2007
for an OTS, which we were agreeable. We deposited the initial deposit as per the scheme. They, after keeping the OTS proposal pending for more than a year, they rejected it, saying that since you are in BIFR, we can't entertain it. And then, strangely, just 2 months thereafter, they gave us an offer in another OTS proposal, that is 2011, which contained the same clause. But they said you come and settle here. Only the amount was much higher.
What is challenged here? You have challenged the e-auction cell in your notice.
I have also challenged the part that this court had given me a leave to
Notice is dated 17/6/2025 under Annexure 16.
That is tomorrow. So my rejoinder is also ready, but the affidavit has to be done. So I was only praying your lordship protects me for the over the weekend. I'll file the rejoinder. I'll give a copy to my learned friend by Sunday or
What
Saturday.
weekend? But if you say that tomorrow is the last date,
We can the final hearing can take place on Tuesday, no difficulty. I just want to put the rejoinder on record.
you have received the counter affidavit
I have
file.
received it only on first.
Okay.
First in
So
court.
you intend to file the rejoinder affidavit, you file, there is no problem. What further you want from us?
Petitioner can be participate because letter has been issued to the petitioner to participate in the auction.
We have already paid. It's not a question of any principal outstanding or running away by not paying. The loan amount was initially 30 lakhs. And it was a running unit which was seized, which was not supposed to be seized.
Mr.
Now
Palit, what he says that you are not debarred in participating that tender trust. So
the rates, now what the difficulty one I'll explain. Lordship, let the rejoinder come on record, I'll explain how they have handled it.
No, that we are giving time there. You say that some interim order is to be passed, so that is why. Suppose it is passed against, suppose somebody else become the successful one. So you are to implead him as a party.
That is the reason I want some protection there. That's the reason I want some protection.
Once they know that this type of order is passed by this court, they may.
This is a case. This is a case. Your Lordship may kindly bear with me. This is the case. We are not.
When a lot of decisions are there, as you know, that tender matters where is the scope unless.
I bow down, Manoj. This is not one of these cases where, my lords, it is the loanee who's at fault. Here, my lords, the loaner is at the agency is at fault, corporation is at fault, and it's on the face of it, writ large on the face of it. Today morning, I give you an offer in 2007 scheme. How palpable? And I'll tell you, I'll be settling. I pay the initial deposit as per the scheme. You keep the matter pending for more than a year. You reject it for no reason, no apparent reason. And then on inquiry, I learned that since it was pending in the BIFR. In the BIFR, incidentally, I settled the State Bank of India, all kinds of.
What we think that
exactly 2 months.
We do not know what will happen tomorrow because it may fail as it sometimes happens, and or a third party right may be created also. So that is exactly the reason why. And once we pass this order and it will
my difficulty is what are they interested in? They are interested in some money.
Yes, money.
Which is only managed by way of some interest.
Money, but in view of our scope.
Lordship may see the difference. 30 lakhs, 6 crores. And I have already managed.
The unit has been seized in the year 1996, my lord.
Not only that.
Since 96, my lord, at least 5 writ applications, including this, my lord, have been filed, my lord. Orders have been passed. He has not complied. Your lordship has come to page 23 of my counter.
When it was
order was passed by this honorable
amicable settlement.
Yes, granting him liberty to approve the OSFC, my lord. He has not applied. Despite that, my lord, petitioner has given a notice. The corporation has given a notice to comply the 2011 OTS scheme, my lord. That he didn't say, my lord.
That is
again, he filed the application, my lord.
You may see that's palpable. 2007 scheme, I'll show it, man. I'll demonstrate on the records. I'll demonstrate it. My lord,
He himself was offered,
on the date,
2011,
on the date,
in the consideration amount, my lord.
on the date of seizure, my machines worth 3 crores were there. You seized it. It was under your watch and ward. Now the industry has been run to the ground. You are charging me watch and wards every month. You are charging me watch and ward, and my machine mallets are not to be seen. What did I say? I tell you that you give me an account statement and you give me an inventory. What is there? We have to see whether you have to pay me or I am to pay you. Machine down.
We are just.
That was given, my lord.
We are
That was given by
we are doing one thing.
Man.
We are just keeping this matter to next week.
Yes.
We are giving you that you file your rejoinder affidavit in the meantime, and let us wait what is going on happening tomorrow. And obviously, if a third party is created, interest is created, you are supposed to add also that. Thereafter, it can be better way adjudicated, because that would be otherwise, if we pass any kind of interim order, that would be.
I fully understand.
All right, we have one.
Possession may not be handed over. No rights may be.
The learned counsel for the petitioner, Mr. Palit, submits that he has received the counter affidavit filed by the opposite party corporation on 1st of July 2025, and intends to file a rejoinder affidavit by next week.
By Monday.
By Monday. And since the auction is going to be held tomorrow, some kind of protection may be granted to the petitioner, and the sale may not be finalized. Right? In view of such submission, list this matter on 8th of July 2025.
7th or 9th, my lord? 8th, I have some.
9th of July 2025. Rejoinder, if any, be held in filed in the meantime, serving a copy on Mr. Das, Land Senior Advocate, and the auction are scheduled to be held tomorrow, may go on, but the sale shall not be finalized till next day. Yes.
Let you proceed with the auction.
Yes, ma'am.
Don't finalize the sale.
Yes, great.
Don't issue sale certificate.
Yes.
If somebody else is succeeded, he has to be included.
Surprise is running in loss, my lord. Relative knows OSFC. But it,
not because of
Mr. Das, another OSFC matter we see, but it is so rigid you are becoming this financial corporation. We do not know that OSFC, the other, even if in Lok Adalat we find that the private insurance company are more liberal in
yes.
For your lordship,
No.
in Lok Adalat.
This was also placed in local said that it should be finalized on the best of OTS scheme.
That's what my brother is saying. You
Yes.
have to, you should not be rigid.
No.
Somebody is paying, taking.
No, my
Local company.
Your age it is you are suffering.
Here, my lord, ample opportunity, my lord. Ample opportunity has been given, my lord. Since 96, your lordship, you can imagine.
Our unit taku 96 ru siege kala pore
Running
interest, interest, upon mane gote pare seat mane kichi dei jauchi.
30 lakh tickets, 70
He has filed case, has taken interim order. We are unable to proceed for sale, my lord.
Now you are demanding 6 crores, 30 lakh loan, 6 crores, 70 lakhs he has already paid.
Yes. No, he has agreed for 1 crore 94 lakhs.
Mane calculation ne kale you are right, but
No.
take into account
that I can
the
understand.
person.
That is delayed payment interest. And no, he
Business
has
keeps it
agreed,
anyway, look.
but he has agreed to pay. He has agreed, my lord, your lordship will file. He has agreed to pay 1 crore 94 lakhs. That we have given time.
Lok Adalat re case gala beଳକୁ ସେଇ rigid stand ଯୋଉ ନଉଛନ୍ତି କେମିତି amicably settle ହବ ସେଇଥିପାଇଁ private companies ମାନେ ସେମାନେ ବହୁତ ସେମାନେ ଦଉଛନ୍ତି ଏତିକି.
You honestly tell, OSFC is litigating in almost all the matters. Almost all the matters.
You see the Lok Adalat results also.
Yes.
You can find that. It's a rigid approach chale Lok Adalat.
No, here he has admitted and failed to comply the order.
We are just saying about that what is generally happening, that why other matters private company loan matters that have been amicably
settling.
settled. But why there is difficulty in OSFC matters? Because of this rigid stand taken, that is the creating the difficulty.
Many private banks are waiving all interest amount and principal amount नहीं भी कर दो
State Bank of India माना.
Principal amount नहीं भी कर दो
Others have been settled.
No, just I'll
communicate this also.
We all these express this before a senior advocate to apprise the authorities.
Yes.
That this is the concern, and you should tell them that don't be that rigid, person.
Even today, you can give a reasonable figure. They may consider and pay it and finish it up.
That was given, my lord. 1 crore 91 lakhs. He has agreed. He has paid 2 lakhs 97,000 as earnest money.
By the time he will arrange 1 crore, you will ask 6 crore.
No.
And you will take that one.
No, my lord.
That's what
He
is
has
happening.
He has not paid, my lord. He has not paid within the stipulated time for which delayed payment interest was calculated, my lord.
The poor businessmen arrange the money and pay you. Whatever they pay, you take it and
see the calculation. See the calculation. He has agreed to pay 1 crore 94 lakh. That way, ready to accept.
ସେ 5 ଥର ରିଟ୍ ପିଟିସନ ଫାଇଲ କରିସାରିଲେ ଆପଣ ଚିନ୍ତା କରନ୍ତୁ ତାଙ୍କ ଅବସ୍ଥା କଣ ହଉଥିବ ଆଉ he is fighting it because engaging Mr. Palit. So
the petition is also a big shot, madam. Petition is also a big shot, madam. Petition is also a...
I'm grateful for
what
30.
No, it has item number
30.
30.
No, there are two matters, no?
There are two
matters.
One can also be cut down. 1614.
We will pass this order in item number, the first item, na?
First
item.
17064.
Also, WPC number 16114 of 2011.
Mr. Palit, submit that another connected.
That was disposed of.
Yes. Just for reference. Tagger for reference.
Submit that records of so and so, which has already been disposed of, may be relevant for the adjudication of this writ petition. The same may be placed. Place this matter on so and so already with WPC number so and so.
Great. One thing, it should be disposed of on that so that the corporation can.
If it will be reasonable, it will be disposed of.
Yes.
You advise your client to be reasonable and they'll pay.
I will appraise them.
That's all.
Great.
Approve.
प्रकाश बेहरा नंद किशोर सेठी वकील बाबू ना दिया जी हाँ अपन मैंने पसंद
Supplemental list, item number 1.
The unit leadership cannot be marked under 293 for fair use. 39. 39. First, in the prosecution case, on the aspect of DNA profiling is that expert who conducted the DNA examination was not examined in the evidence, and the DNA report was merely executed in the evidence by the investigation officer, Tribunal 14, who undeniably is not connected with the report in any manner. This court, in the case of Rahul versus State of Delhi, Minister of Home Affairs, while dealing with the issue concerning the evidentiary value of the DNA report, held that DNA profiling reports cannot be admitted in the evidence ipso facto by virtue of Section 290 CRPs. It is necessary for the prosecution to prove that technique of DNA profiling was reliably applied by the expert, the relevant expert from the state judgment reproduced hearing for the sake of ready record.
Read out.
Article 6. The learned amicus curiae has also assailed the forensic evidence, that is, the report regarding the DNA profiling dated 18/4/2012, Exhibit P23-1, giving intimating findings. She vehemently admitted that apart from the fact that the collection of the sample sent for examination itself was very doubtful, the said forensic evidence was neither scientifically nor legally proved and could not have been used as a circumstance against the appellant accused. The court finds substance in the said submission made by the amicus curiae. The DNA evidence is in the nature of opinion evidence as envisaged under Section 45. Like any other opinion evidence, it is probability value varies from case to case. 38. It is true that PW23, Dr. B.K. Mahabhadra, Senior Scientific Officer Biology of CFSL, New Delhi, has stepped into the witness box and his report regarding DNA profiling was exhibited as exhibit PW23/A. However, mere exhibiting document would not prove its content. The record shows that all the samples related to the accused, related to the disease, were seized by the investigating officer on 15/2/2012 and 16/2/2012, and they were sent to CFS for examination 27/2/2012.
After about 10 days, 12 days, yes. During this period,
they remained in the Malkhana of the police under the circumstances. The possibility of tampering with the samples collected also could not be ruled out. Neither the trial court nor the High Court has examined the underlying basis of the finding in the DNA report, nor have they examined the facts whether the techniques were reliably applied by the expert in the absence of such evidence on record. All the report with regard to the DNA profiling become highly vulnerable, more particularly when the collection sampling of the samples sent for examination were also not free from suspicion. Here, my lord.
Read out.
Yes. The facts and circumstances of the present case, non-examination scientific expert who carried out the DNA profiling is fatal, and the DNA report cannot be admitted in evidence. That apart, we find that very procedure for collection and forwarding of the DNA sample to the FSL is full lacuna and loopholes. The incident took place on the intervening night of 25th June 2016. The dead body of the child victim was picked from the crime scene by the investigation officer Tribunal 14 on 26th June 2016 at 6:16 p.m. and was forwarded to the Dr. Madan Mohan, Medical Officer PW7 for carrying out the postmortem examination. The medical officer, while deposing on oath, stated that he collected following samples and articles from the child victim dead body for forensic examination. The relevant expert from his testimony is reproduced below. The following tests were sent from the injuries of the deceased in her vagina. Number 1, extract was collected from the vagina and 4 slides were prepared for spectromajo and smega test were sent to laboratory. 5 ml blood was taken from the body of the deceased and the sent for DNA test. The hair stalk on the vagina of the deceased and the blood accumulated outside
the vagina were also sent for DNA test. The following clothes of deceased were sent in a sealed bundle for semen and blood test. Clothing of the deceased. Number 1. Ready-made blue underwear stained with blood. Mud. You come to Printed-
paragraph 42.
The medical officer, P. 7, also stated that the sample of the deceased as well as the appellant were handed over to the police officer who came to the hospital for contemporaneous points of time. However, there is not even a whisper in the statement of the medical officer, P. 7, that the sample collected from the appellant were sealed prior to being handed over to the police officer. Hence, at very inception, the procedure for collecting samples has been tainted on account of non-sealing of the forensic material collected from the accused appellant. If you kindly see, madam, para 51, madam.
Investigation officer also deposed.
Madam, the investigation.
Also deposed that.
The investigation officer P. 14 also deposed that the medical officer P. 7 had handed over the samples articles for forensic evaluation and DNA profiling, which is duly sealed and was sent for scientific examination. However, the fact remains that neither the documents, memorandums pertinent to the proceeding or sealing the said samples articles were exhibited in the evidence, nor did any of the prosecution witness gave evidence for providing this vital procedure. 52. A bold assertion was made by the investigation officer, Tribunal 14, that on 26 June 2016 and 28 June 2016, the bodies of the appellant and with sample of the blood, hair, and slides of vaginal smears and swabs of the child victim were prepared and sent to the FSL for DNA profiling and the forensic examination by the permission of the court. 57. Nevertheless, the fact remains that the evidence of the investigation officer, Figure 14, is totally silent regarding the deposit of the samples article in the Malkhana or the police station or mode or any manner of the transmission thereof from the police station to the FSL. No foreign letter pertaining to the transmission of sample was proved in the testimony of the investigation officer, Figure 14, or any their police witness. The Malkhana in charge or the police station was also not examined by the prosecution.
This is important.
What on the next paragraph? In order to make the DNA report acceptable, reliable, and admissible, the prosecution would first be required to prove the sanctity of and chain of custody of the sample articles, right from the time of their preparation, collection, till the time they reach the FSL.
This is the sine patricia observation, I would say. Right from the time of collection till it reaches there.
For this reason, purpose, the legal evidence would have to be established by the exam in the concert witnesses. Evidently, there is not even a semblance of evidence on record to satisfy the court that sample articles collected from the dead body of the child victim and those collected from the appellant, which were later forwarded to the FSL, were properly sealed, and or that they remain in the same condition right from the time of the seizure till they reached the FSL. No witness from the FSL was examined by the prosecution proved that the sample articles were received in a sealed condition. Hence, that every possibility of the samples being tampered, manipulated by the police officer so as to achieve a favorable result from the FSL, thereby inculpating the appellant in the crime. Consequently, we feel that DNA FSL report cannot be read in evidence. Once the report of the FSL is switched from consideration, there remains no evidence on the record of the case so as to connect the appellant with crime.
Oh, here, Mr. Mulia, what has happened here when the exhibits were forwarded to court, in that forwarding report, it is mentioned that some of the items were sealed and other items, nothing has been mentioned. And no, let us say nothing has been mentioned. And when it was produced in the court in that order sheet,
there is no mention in what condition it was produced and that the court sealed all those articles. There is no mention. But when it reached the for the C examination, that was the receipt. There it is mentioned that each of the articles were sealed. So the question is that if it was not produced in sealed condition, some of the articles, and it was not also sealed in court because that is lacking, the evidence is lacking. Then when it was sealed, who sealed it? It was handed over to the IAC. Right. He was not examined. Who was not.
And in this case, the samples were sent after 10 days. Yes. About 10 days, 10 to 11 days. In this case, it is 2 months.
In this case,
it is more than 2 months, more than 2 months.
Right.
And it changed hand to IOs. The other IO who was subsequently really handed over to it, the facility was not taken.
What is the articles for the FSL also not stated in the manual, who examined the 23. But I think earlier decisions are there that I think they have taken now a different view, but earlier decisions were there that the DNA test report, this fingerprint exports report that can be marked as an exhibit. The defense has right to file an application before the court if they want to call for that export for examination. They can. Otherwise, it is not a normal that in every case the export should come and prove it. This particularly this 293 रे जो documents गुड़ाक आसुची से गुड़ाक सेतिपाई decision चुला, but they have
now taken a different view. Different 3-judge bench 2025.
Here in this present case, Maila, that's the DNA test report. There is a discrepancy. What is this? No, just a minute, Mr. Mulia. This court in the case of Rahul versus so and so, जो 19 नंबर दी चंदी 19 नंबर रेफरेंस
2023
You have the judgment.
2023 volume 1 SCC page 80.
Volume 1.
Volume 1.
SCC
page 83.
You got the judgment.
The pass on.
Para 36 is the report.
36. Because the language of 293, as we read that day, that the court may examine, that is the language, I think 293 wrong. Yes, 293.2 says that reports of certain government scientific exports. So, the court may, if it thinks fit, summon and examine any such export as the subject matter of this. This has been interpreted that if after going through the same, even nobody has applied for the examination of the scientific officer, if the court feels that he wants some clarification, he can call the witness and can examine as a court witness also. And apart from that, if the defense also files a petition giving reasons that why he wants to examine the export, then also the court has to consider the same and pass appropriate order. But now they has taken totally a different view that you cannot mere exhibiting document is that is not relevant. It has to be examined. These are all there. This Malkhana, this all these things we have already. But supply the judgment of Rahul Minor. Rahul versus
36 and 38. That is reproduced there.
Judgment Minor. No, but Mr. Mulia, we just want to know from you that in the case in hand, that exhibit list indicates that DNA report, which was marked as exhibit without any objection. So you have not objected marking the same as an exhibit. So the question is that whether such a thing has happened in this case, that the defense has also not objected to the marking of the, because that witness has also been examined, I think. Scientific officer was examined, but he has simply marked, where is that line? EU case re, the export ta examine hala. Order sheet of the, in the present case, non-examination of the so-and-so is fatal, and DNA report cannot be admitted. That part we find that very procedure, that's different. No.
In the Rahul judgment 105, reasoning is this judgment. Page 105 for the full. Collection and preservation of evidence. Why for it is view?
Which paragraph?
Page 105.
105.
You just read it. Page 105 in Rahul judgment.
Another copy of the
Rahul judgment you have?
Yes.
Read it. Page 105. Collection and preservation of evidence. You read that part. That's precisely the reason why they have taken that stand. Last 105 page.
Yes. Here they have actually taken into account one article published from the Central Forensic Science Laboratory Kolkata. That was relied upon in that case of Manoj versus State of MP, and that they have extracted here. So
this is relevant.
Read it out, read.
This is the literature basically. If DNA evidence
If DNA evidence is not properly documented, collected, packaged, and preserved, it will not meet the legal and scientific requirement for the admissibility in a court of law, because a small sample of the DNA can be used as evidence. Greater attention to contamination issues is necessary while locating and collecting and preserving DNA evidence can be contaminated when DNA from the another source case mixed with DNA relevant to the case. This can happen when someone sneezes and coughs over the evidence or touches his or mouth, nose, or other part of the face, and then touches area that may contain the DNA to be tested. Accused having biological specimen which can establish link among victim, suspect, scene of crime, or solving the case should be identified, preserved, packed, and sent for DNA profiling. In an earlier judgment,
so the threat of contamination is so high, so the preservation is very, very essential.
You come to paragraph 38. That was that in that case, the person concerned was examined, that scientific officer that you are reading.
Same para 30.
Para 30.
108 page. The top. It is true that.
It's true that the period 23, Dr. Vikram Mahodra, senior scientific officer, biology of CFSL, New Delhi, has stepped into the witness box. In a report regarding DNA profiling was executed as exhibit PW23A. However, mere exhibiting a document would not prove its content. The record shows that all the samples relating to the accused and relating to the deceased were seized by the investigation on 14/2/2012 and 16/2/2012. They were sent to CFSL for examination on 27/2/2012. During this period, they remained in the Malkhan of the police station. Under the circumstances, the possibility of tampering with the samples collected also could not be ruled out. Neither the trial court nor the High Court has examined the underlying basis of the findings in a DNA report, nor have they examined the fact whether the techniques were reliably applied by the expert. In the absence of such evidence on record, all the reports with regard to the DNA profiling become highly vulnerable, more particularly when the collection and sealing of the samples sent for examination was not free from such.
Here in this case, it was put in the Malkhana. Still they took a,
But no evidence they put in Malkhana.
in our case, this case, but no, this in the Rahul case.
Yes, madam. Rahul case was kind of page 89, madam. Page 89, madam. Personal age, evidence at 970. Personal evidence. Condition need to be fulfilled by the prosecution or 5 of the golden principles, which constitutes the constitution of the proof of a case. That is settled.
Sarad
Bricham Sarda, 84, Supreme Court. Okay, any other submission you want to make? No judgment, madam. On which point? Another judgment, my lord. That's identification. Delay identification after 2.5 years. Para 22, madam.
22.
Page 5 looks. 50. 563, madam.
Yes, brother.
22.
Yes.
So Deming Sutal Kumar, people 12, was also made to identify the accused person in the dog. But that is another story, which we shall consider as the later stage. Thus, witness identify the appellant and accused as the offenders. However, we find that the lame attempted by the people 12 to make dog identification of the accused in his deposition recorded after nearly 2.5 years of the incident is absolutely flimsy and unacceptable. The witness had not given out either the name or description of the feature of the accused in his police statement, and thus, if at all, the prosecution was desirous of getting the accused identified at the hands of this witness, then he should have been made to identify the accused person. The text identifier is no English. Thus, the identification of the accused by Demis Kumar, period 12, for the first time in the dock is totally unbelievable and unacceptable. You know, my lord, so witness period 36, my lord, was deposed for the court after 6 years. 37 or 36? 36. The last inquiry. No, he has seen the accused, PW 37, has seen the accused in the night, stated to be in his grocery shop for 10 to 12 minutes. And there is no evidence on record that what kind of light was there in his grocery shop, whether it would be sufficient to identify or remember the person for such a long period. And here also no special feature of that accused has been given by PW 37, that there is some kind of peculiarity in the person's face or this, that, so that he can remember and identify. So that sort of evidence is not missing. So maybe that somebody who was having a lantern, let us say, or a lamp in the grocery shop, and a person comes for few minutes to his grocery shop with another person and takes these water pouches, etc., and sits there for some time and goes away. And after 6 years, that man is identifying him in court. So that is how it's stated that it should be backed by a test identification, parent identification, which is usually done in such type of case to see that the investigation is in right track or not. Because the person who have been apprehended, whether they have been correctly apprehended or it was just at the whim and pleasure or some suspicion they have been taken into custody. So that is the desirability, and with all precautions that is to be also conducted. Here that has not at all been conducted, the TI parade. So that is why your submission is that after 6 years, the court identification by PW 37 should not be accepted, right?
Para 45, 46 that judgment, that's the kindly see. Para 45 and 47.
45.
Yes.
Same judgment?
On 6 other judgment.
On a threadwear.
On a there analysis of entire record, we do not find that the prosecution examined any witnesses for report about the link of evidence, safe custody of Modumal articles right from the time they were received at the police station and ceased till the time they reached the FSL. And otherwise, also the FS report exhibit 111 to 115 pales into insignificance. The investigation officer, P 18, reports that he arrested accused person. Detailed inquiry is made from all three appellant accused. They were examined for the injuries found on their body. Therefore, all the appellant accused confessed their willingness to clear the place of offense. There were Panchanama and as per the section 27 evidence act by facts. Since the place of incident is also known to the police, this disclosure is driven search of the house of the appellant accused was undertaken in the presence of the punch witness, and a big knife was seized from the house of the accused, Muhammad Farooq alias Pallab, by Panchanama. Hence, we are firm view that neither the disclosed statement made by the accused were proved as per law, nor the same resulted in any disclosure which could be accepted as incriminating in as much as the requested link evidence was never presented by the prosecution as to establish that the recorded articles remain in the self-set condition from the date of the seizure till same reach the FSL. And by and large, this
the main thing is that this defense counsel, whosoever may be, has done the thing that he had not put any question that how you identified him. Otherwise, such type of blunders are created nowadays. Because the witness in the chief examination is just stating that he came in the night, remained there for 10 to 12 minutes, and then went away. And questions are being put that Tomo Yere Kono light thilla, amok thilla, so they used to bring it in the cross examination. Light thilla, bar light jol thilla, amko jol thilla. Fortunately, nothing has been put in that way in the cross-examination.
You give prosecution to prove its case.
No, that is exactly, but what the prosecution sometimes has not placed in the chief examination, the defense counsel brings it in the cross-examination.
Here what happened, my lord?
That is the
appointment. Again, SDC appointment.
So,
Then again another SDC was my lord appointed.
So here that has not been put, but we find that in. That is the fundamental thing that a cross-examiner should know first that what not to ask and what to ask. That is the. So. Yes, anything else? Okay, yes, Mr. Tripathi. Now this decision which he has placed on the DNA test report, the person who has, who is the author of this DNA test report, if he has not been examined,
it has to be discarded.
And it is just marked as an exhibit, even if he has not objected to the same. The question is that it is just marked as an exhibit, but it would not prove the contents. That is the language that has been used by the three-judge bench decision in 2025, relying on the earlier
2023 decision.
The earlier decision was also three-judge bench, and that was relied upon in 2025, and it says in clear terms that thus, in the facts and circumstances of the case, so and so, non-examination of the scientific expert who carried out DNA profiling is fatal, and the DNA report cannot be admitted in evidence. Mere marking, what is that word has been used? That even if it is mere mark, it would not mean the contents, mere exhibiting. That is the language used here somehow.
Exactly the same thing happened in your case. Any contrary judgment, anything in this point?
I will search for it now. I got.
It is as recent as 2025.
25, and they have relied on 2023 decision.
And the three judges both.
Yes. Both.
This is March 25. 4th March 25. What are the judgment you are saying?
Before coming to the judgment, may I draw your lordship's attention to page 100 of volume 1.
Volume 1.
Well, unfortunately, I skipped that portion.
No, just a minute. Mr. Mulia, one line is there that mere exhibiting the document would not prove the contents of that, this DNS.
Yes,
there is some line
yes,
somewhere. I just read it out and marked it. This judgment you just now placed, somewhere it is there that. They have quoted from Rahul's case. It is Rahul's case, paragraph 39.
Over mere exhibiting
that is important. Mere exhibiting a document would not prove its contents.
That is para 38 of Rahul.
No, Rahul case. And that they have relied upon, quoted, accepted, so that is how. And they stated that non-examination of the scientific officer, they are in that Rahul case, scientific officer was examined.
Yes, must be.
Here they is
not examined. And in this recent case also, the scientific officer,
and both the
2025 cases also, that was not examined.
But only through the scientific officer it was exhibited. The content was not. The court says that mere exhibition, even if we examining scientific officer, the content is not treated to be proved. But here, even the scientific officer is not examined.
And there is
Exhibited through
there is a discrepancy.
DNA.
IO.
Exhibited through IO.
Yes,
That's
there is a
one.
discrepancy in the DNA test, my lord. In conclusion and the.
No, that's a different matter. You are questioning on the legal
Application of this judgment, which is this case. Yes, 100 you are showing.
Yes, correct. That is
PW4.
The other day, let's see, put a question to me whether any material is there in the record which can show regarding the second motive, Millard, political rivalry. I skipped that, Millard. Let's see, can you see page 100? At a relevant portion, it's at page 101.
Para 4.
Para 4, Millard. Para 2. 101, para 2.
You have placed it.
That
We
we
have
have marked
marked it. There is no question of non placing it.
PW4.
That contesting thing.
Yes.
That Dilip's wife.
Dilip's wife.
But you have not put a single question to Dilip.
Now Dilip's friend says that, Millard.
Dilip's wife is not examined. You have examined Dilip.
And the contest was for some other thing. One witness says that
ward
it
member
was for Sarpanch, another day it was for ward member.
Here both the things are stated. Paragraph 2. Sarpanch and ward member election.
But these two motives are diagonically different motives. The fact that all of them were together, there was no animosity between them. They were friends. That is the reason they were drinking together. If this motive, the second motive is to be believed, the animosity would have been there. There is no animosity. Rather, they were drinking together.
You just think about it. Suppose they were pretending very good relationship with the deceased just to take away him and committed the murder. Right? That was their first intention. So they should have kept him away from that grocery shop or bringing to any persons, because in future when those persons will be examined, they will say that we have seen the deceased in the company of the. They would have said that to deceased, you wait here at a isolated place or dark place, and they would have themselves go to the grocery shop to bring the pouch. They would not have exposed themselves in the company of the deceased had they intention to commit the murder.
One more thing.
So that is the general thing. Apana jana kouchandi je semane hueta pretend korte motive thibo tenu friendship deikin taku gharu dakikin nei chali gale. So that tar bi doubt habani se bi oppose karibani kintu tar plan thila taku murder karibaku.
The second motive you try to implant in the story only to justify the two murders. If this motive is accepted, the election thing is accepted, then Biranchi's murder can be justified. They could have killed Biranchi because of this motive. But if this motive is to be believed, why the other two murder? The other two murder is connected to the second motive which you are imputing. Both the motive can't go together.
And that is disbelieved by the contract.
But second motive you have brought in only to justify the other two murders. Because robbery and all. They wanted to take money, so therefore second two motives. And the first motive, which is Biranchi, which motive you want to stick to? Both the motives. If the first motive you stick to, then the second motive goes. Because you have to justify these two other murders. Whichever is these two other murder, you are bringing the second motive.
Yes.
And whichever is the first murder, you want to bring this motive.
Now one thing may be possible, Millard.
So this story appears to be a bit...
Melody place 1 and place 2. Let's see, kindly resume that, Millard.
Yes.
Melody place 1 and place 2, Millard. Melody. He took him to the place 2, saying that place 1 Melody.
Why they will bring him at all to grocery shop and the liquor shop if they had planned to commit the murder? We are asking you a question. X, Y, Z are the three person. Okay. So your case is that X and Y are have an intention to kill Z. And that is how they were pretending good relationship and they took with him. And first they took to the liquor shop, then to the grocery shop. Then they say that this melody is not good, let us go to the another melody. And in the isolated place, they committed the murder. If that would have been the case, whether they would have exposed themselves to the that grocery liquor shop you have not examined. We are questioning on the liquor shop. Liquor shop evidence is PW 37. PW 37 कहला जे दी जण accused डिसीज सहित आसिले पाउच फाउच किणिले मो दुकान ने बसिले 10-12 मिनिट तापरे पियापी कले गले राइट दैट इज द एविडेंस तो ताकू सेठी की आनिवार कोन जस्टिफिकेशन थिला एम आको भितर दी जण भितर जणे के चल जाई थांदा जाई किनी पाउच नै किनी पळे आस्तांदा आ गोटे जगह बसी पियापी करथान तापर ताकू नै की जाई थांदे just think over it because it's a question of appreciation. Okay. Generally kon haba katha tanku expose kebe kari suppose let us say in a case of dockage just think over the matter. The case is that it was at the instance of that some of the persons who are very closely known to the informant's family member, they also participated in the dockage. And along with them, there were some unknown persons. So who has to take the lead? Front to ki asibe inmate ro. Unknown persons obviously asibe, not the known persons. So say type ro, ethi jodi samankara plan hochi je taku ye kariya ta dhur janu ku se jani chi jodi ame kahiba एविडेंस अच्छी तो से लोकटा आस्ताना मते दीटा पाउच दियो आउ से एटा दियो तांको कहि दियो ना तुम छिड़ाओ मु नेकी ना आसी सी काहे कि थे डिसीज को नेकी जीवो से दुकान को सो दैट काली सकाळे समान कर प्लानिंग थिवो मर्डर करिवे तापर तन्ना तदंत हबो कहिबा या आस्तिले बोलो तो दैट इज द थिंग एंड मोटिव ये जो सर्कमस्टेंशियल एविडेंस रे मोटिव रो इंपोर्टेंस बहुत रहुची दैट इज द लॉ डायरेक्ट एविडेंस अछि डोंट इवन इफ द प्रोसिक्यूशन हैज फेल्ड टू प्रूव मोटिव इट इज इमैटेरियल बट सर्कमस्टेंशियल एविडेंस केस रे consistently it is stated that it has got pertinent significance and it is one of the limb in that chain of circumstance. So when the prosecution in a case of circumstantial evidence fails to prove the motive or the motive that has been proved is very weak type of it, then the court becomes more careful and the court has to scrutinize the rest of the circumstances in a very thoroughly to see that all those things taken together forms a chain. ଆପଣଙ୍କର ଜଣଙ୍କର 3 ଜଣ ଆକ୍ୟୁ डिसीज ରୁ ଜଣେ डिसीज ସହିତ ଆପଣ କେବଳ ଲାଷ୍ଟ ସିନ୍ ପ୍ରମାଣ କରିଛନ୍ତି ଆର ଦିଟା डिसीज ସହିତ ଲାଷ୍ଟ ସିନ୍ ନାହିଁ କିଛି ନାହିଁ କେବଳ ସେ ଯୋଉ DNA ଟେଷ୍ଟ ରିପୋର୍ଟ ଏଇ ଯଦି ସାଇଟେସନ ଟାକୁ ରିଲାଏ କରାଯିବ ଆପଣ ଯଦି DNA ଟେଷ୍ଟ ରିପୋର୍ଟରେ ସେ ଦିଟା ମର୍ଡର ପାଇଁ ଏମାନଙ୍କୁ କନେକ୍ଟ କରିଥିବେ ତାହେଲେ that goes there ମାନେ the accused person cannot be held responsible for the commission of murder of those two deceased only basing on the link of DNA test report finding. बाकी रहिला ए बिरंचीर केसटा बिरंचीर होची गोटे होची लास्ट सीन आ गोटे मोटिव तो देखिले बाकी होची तृतीयटा होची DNA टेस्ट फाइंडिंग तेणु अगेन DNA टेस्ट चली जीवो रहिला लास्ट सीन and that motive weekend motive last scene no jo evidence that is very doubtful because 6 वर्ष परे TI पैरेड न करिकिने आपण कोर्ट आइडेंटिफिकेशन करूचंती आउ इनफैक्ट 161 रे आमे देखिलु दैट नो नेम इज देयर सो and he से निजे मध्य कोची क्रॉस एग्जामिनेशन ने मु डिसीज को जानिनी आ भितर गोटे अपेलेंट को फर्स्ट टाइम मु देखिली से दिन आ गोटे लोक ता धेरु मु चिनी ता पर दिन कोची गोटे वीडियो वायरल हला देखा गला जे जो मर्डर हला ସେଇଥିରୁ ମୁଁ ଜାଣିଲି ଯେ କାଲି ଯୋଉ 3 ଜଣ ଲୋକ ମୋ ଦୋକାନକୁ ଆସିଥିଲେ ସେଇ 2 ଜଣଙ୍କ ଭିତରୁ 2 ଜଣ ହଉଛନ୍ତି ଇଏ ଆଉ ଯୋଉ ଡେଡ୍ ବଡିଟା ହଉଛି ଇଏ। ସେ ଭିଡିଓ ଯୋଉ ଭାଇରାଲ ର କ୍ଲିପିଂ ହିଁ ଏଭିଡେନ୍ସ ନାହିଁ। ତେଣୁ that should have been also collected by the investigating agency ହେଲା ଯେ ସେଟା କଲେକ୍ଟ ହେଇଥାନ୍ତା ତାକୁ ପଚରା ଯାଇଥାନ୍ତା ଯେ this is the video link ଯୋଉଟା ଆପଣ ଦେଖିଥିଲେ ଆପଣଙ୍କର ବହୁତ ମିସିଂ ରହିଛି ସେଇଥିପାଇଁ yes anything else
only to one recent decision on motive.
କୁହନ୍ତୁ
Paragraph 24.
just a minute. Hmm. 20?
24 is relevant.
Is it a case based on direct evidence or circumstantial evidence?
This is circumstantial evidence.
Circumstantial. Hold on.
Motive remains hidden in the inner recesses of mind of the perpetrator, which cannot often than ever be ferreted out by the investigation agency. Though in a case of circumstantial evidence, the complete absence of motive would weigh in favor of the accused. It cannot be declared as a general proposition of universal application that in the absence of motive, the entire inculpatory circumstances should be ignored and the accused acquitted. Now they have referred to other decisions made at paragraph 20. Paragraph 22 and 24.
No, we are not telling you that we merely because you are the motive. Here you have adduced some evidence relating to the motive, and we find that that is a very weak piece. But we are not discarding the prosecution case only on the ground that either the motive has not been proved or the motive which has been stated to have been proved is a very weak piece, and that we are taking into account the entire thing. So what the decision says that even if it is circumstantial evidence, the motive is not proved because it is always in the mind of the perpetrator. That cannot be a ground to disbelieve the prosecution case if the other inculpatory circumstances make the chain complete. Hela? So motive न थाउ यदि अन्य circumstance गुड़ा को chain complete करती है ताहले भी circumstantial evidence से ही परियो.
So far 293 is confidential.
No, see the motive is there or not, that's one issue.
Yes.
But having portrayed two motives, not proving it is a different issue. In your case, you have portrayed two motives, two different stories of having two different motives and not able to prove it. That is fatal.
If
this paragraph is to be believed, in this paragraph, it says that motive may not be necessary. But once the prosecution put forth two stories to justify three murders and thereafter miserably fails it, then it is fatal.
Here in this case, prosecution also failed proving the motive, but other chains of circumstances they succeeded. Here, in the present case, so far 293 is concerned whether his scientific officer is to be examined or not. My Lord Senior has submitted that judgment of the recent judgment 2025. If your Lordship permit me, then I will make a research on
the
that.
Recent decision, how can you March masare judgment
4th March 2025.
March 2025 judgment, and that is relying on another three judgment of 2022 or 23.
23.
हाँ 23 रो नहीं से जजमेंट है जी 2022 रो नवंबर है
Yes, yes,
अब ये जजमेंट टा जो सी प्लेस कले again 3 judge bench decision that is of 4th March 2025 so 4th March परे आपण कोन गोटे आनिबे 5 judge bench रो डिसीजन थोइबे जदी जे नहीं that's a different otherwise this is the law laid down so
these general principles are all right. Insufficient.
anything else Mr. Tripathi
No,
Mr. Mulia and Mr. Panda anything you want to say Ajay amicus curiae
regarding sentence. While imposing the sentence, the current trial court has not considered the mitigating circumstances and has also not
that is how we
obtain the affidavit report and all.
We just did all these exercises. That was the reason why I said that when that has not been done, the appellate court has to do all these exercises. We afforded an opportunity to him and we also collected the reports from the jail doctor, the antecedent, the probation officer went to the village, the psychological condition, the post-conviction conduct, the pre-conviction conduct, everything. Those are to be brought on record as per those decisions and we have brought it on record. So,
they see our order dated 18/6/2025.
You have seen that already. What has not been done, we have done also at our stage. So now all these things are before us. So the question is that even if we suppose we held the appellant guilty under section 302, definitely we have to take into account these reports that and we have also asked them to have their say by filing affidavit. They have also filed the affidavits. Because if we, let us say, we are thinking out loud, if we say that the prosecution has proved the commission of murder of only one deceased by the, let us say hypothetically, not the other two deceased, okay? This death sentence was imposed for commission of triple murders. And if the prosecution fails to prove that the other two deceased, the petitioner's involvement, then it comes to one deceased. So whether in such circumstance, death sentence is to be imposed or not. That is another thing, right? So, okay, let us ask them. Prakash Behra au Nandakishore Sethi. तो आपण मानकर वकील बाबू माने आउ जो कोर्ट जो जन को पंडा बाबू को एंगेज करथिले अमाइकस क्यूरी हिसाब रे कोर्ट मित्र हिसाब रे सेमान को आमे सुनिलु आउ सरकारी वकील बाबू को मध्य सुनिलु आपनकर एफिडेविट मध्य जहा देइथिले ताकू ग्रहण कलु तो ए केस वर्तमान आज जजमेंट पाई रहिबो तो आपनकर आउ किछि कहिवार अछि ए केस विषय रे आज्ञा कौन कहउछन
आपत्ति अछि
कोन कहवा कथा कोन
मते जो दिन घर पुलिस वाला आनले थाना रूम पे साथे नहीं गिरी सारे मते लोग देले
आपण आगे कहतु तापरे आपण कांदिले कहले ये आमे सुनिबा दरकार आपण कोन कहिया चाहउछन कहतु
पुलिस वाला मते घर तोरी गिरी आसले पेन साथे रात रे मोड पुलिस गिरी नहीं होते
उनसे कोजी को
पुलिस टॉर्चर करे नहीं
पुलिस आपण को घरु नेला तापरे कोन कला
थाना रे रखी गिरी मो पेन साथे पुलिस गिरी नहीं
कौन से इको होची कोन भले कि नहीं
पेंशन खोली नहीं गले
पेंशन खोली नहीं
हां पैंट शर्ट नहीं गले आपण घर तापरे कोन कले
सकाळे मो पेन कंप्यूटर जंगल को नेला ओके दिगे लोग आजकल तुमको बोले नहीं गिरी आजकल मुझे आनी गिरी ज़्यादा तेज़ी
আচ্ছা আপন এইটা হউଛନ୍ତି আপন যেটা কହୁଛନ୍ତି সেটা ঘটনার এইটা হଉଛି মেরিট উপরে আমি আপনার কହୁଛୁ এই আপনার যে ফাঁসি আদেশ দিয়াইছি তা উপরে আপনার কোন কহিবার ଅଛି কুহতু আর যে তো সত্যপাঠ তো ଦେଇଛନ୍ତି ଦେଇଛନ୍ତି আউ কোন কহিবার ଅଛି কি ফাঁসি আদেশ উপরে মিছ খালি কହୁଛନ୍ତି মিছ কেস বলে আচ্ছা ଆଉ ଇଏ ନନ୍ଦକିଶୋର ସେଠି ଆପଣ କଣ କରିବାର ଅଛି
ହଜୁର ମୁଁ ଚାଷ କାମ କରେ ଆଉ ମୂଲ ମଜୁରୀ କାମ କରେ ମାଛ ବେପାର କରେ ଆଉ ସେ ଏଇ ସବୁ କାମ କରିକି ପରିବାର ପୋଷେ ମୋତେ ସାର୍ କାଟପଡ଼ି ପାଖରେ ମୁଁ ଠିଆ ହେଇଥିଲି ଆଉ ମୋତେ ପୁଲିସ ବାଲା ଥାନା ବାଲା ମୋତେ ହେଇଠୁ ସାର୍ ଉଠେଇକି ଆଣିଲେ ଆଉ ସାର୍ ମୁଁ କିଛି ଏ ବିଷୟରେ ଜାଣିନି
ଆପଣଙ୍କୁ କୋଉଠି ଗୋଟେ ଛିଡା ହେଇଥିଲେ ସେଠୁ ପୋଲିସ ବାବୁ ଧରି ନେଇ ଆଇଲେ
ସାର୍ ଡେଡ୍ ବଡି ପାଖରେ ମୁଁ ଠିଆ ହେଇଥିଲି
ଡେଡ୍ ବଡି ପାଖରେ ଛିଡା ହେଇଥିଲେ
ଆଜ୍ଞା ସେଇଠୁ ଥାନା ବାବୁ ମୋତେ କହିଲେ ଚାଲ ଥାନାକୁ ଏଇଟା ସେଇଠୁ ଆପଣ ପଳେଇ ଆସିବ ଦସ୍ତଖତ ମାରିକି ପଳେଇ ଆସିବ କହିଲେ ମୁଁ ଏଠୁ ସାର୍ ଥାନାକୁ ନେଲେ ଥାନାକୁ ମୋତେ ଜେଲକୁ ଫରୱାର୍ଡ କଲେ ମୁଁ ସାର୍ କିଛି ଜାଣିନି ବିଷୟରେ
ଆଚ୍ଛା ଆଉ ଏ ଫାଶୀ ଯୋଉ ଆଦେଶ ହେଇଛି ତା ଉପରେ କଣ ଆପଣ କହିବେ କି କିଛି
ସାର୍ ଆମ ଗରିବ ଲୋକ ସାର୍ ଏଇ ଦଣ୍ଡ ଦେବା କଥା ସାର୍ ମୋତେ ଏଥିରୁ ଖଲାସ କରାଯାଉ
Okay, so we are reserving the judgment. So if you ये एडवोकेट बाबू आपण कौन तांको किसी बुझीचंदी किसी कहिबे कि
दिलीप
ना
दिलीप
कुमार कौन दास
falsely implicated in this case, but they have no knowledge regarding the occurrence.
Okay. So, do you want to file any written note of submission, or we'll just close and?
I will file most of the day.
When you will file?
By tomorrow, I will file.
By tomorrow is a holiday, so you file it by Monday. By Monday you file. Memo of citation or any written note of argument, but it should be precisely on the point, not that you should give us a lengthy note. So you have given your written note about it, nothing further. Just take down. Hard. So and so is present. Set up like the previous orders here. And Mr. Satyaranjan Mulia, learned counsel for the appellants in CRLA number 1166 of 2024. Mr. Pradeep Kumar Pandal and Namai Pasturi in death reference number so and so. And Mr. Devasis Tripathi, learned additional government advocate. Some citations were placed by the learned counsel for the appellants as well as by the state, which are taken on record. We have also heard the appellants through virtual mode on the question of sentence stop. The learned counsel for the state submits that he will file the written note of submission along with memo of citation by 7th of July 2025. Stop. Hearing is closed. Judgment is resolved.
Item 2.
Quick substance. Quick substance.
weeks after.
What is your good name, madam?
Devaki Maran.
This has come for consideration of bail application. Have you gone through the file? Mr.
Custody certificate call for.
କେତେ ବର୍ଷ
Item 3.
Wait, please, madam. Taken record.
Yes, that's it.
Your earlier rejected, because I am appearing for the appellant. Madam. My name is to be reflected in the cause list. Asking any Sombar filed with me. Monday I have appeared for the appellant.
তাহার ওকালতনামা আছে, just give it in writing.
Right.
So and so submits that on 30th of June 2025, he has filed the Wakalatnama. Let the registry place the Wakalatnama on record. Is the sole appellant?
Yes, madam, in this appeal.
The name of Mr. Das be reflected in the cause list. The names of other counsel shall not be reflected in the foot of this matter. Put a date the next week. It will come next week. Your name will be there. So you are good in matter.
I'm ready, madam, I can press this.
You are ready. You say, I thought that you are waiting for that Wakalatnama and your name to be reflected. That is how.
I just said because.
Okay. Yes.
Hello, here on strength of oral dying declaration, the conviction is based, fellows. So far as another accused is concerned, he has been released by this honorable court by order dated 7/2/2020. They stand on a similar footing.
Just a minute. Your bail application was rejected earlier.
Earlier, madam, it's rejected.
When it was rejected? Which order it was rejected?
No, sir, upload भी है ही नहीं.
Just a minute. Let us verify that. 18/8/2016. Again on 5/10/2021. And when that other accused was released on bail?
7/2/2020, madam.
That is in criminal appeal number 195. Please, 14. 195.
Oh, the court.
Same footing.
Same footing, madam.
No, before whom this oral dying declaration has been made?
Yes, your lordships, that is PW3.
Schedule 18, madam.
18, PW3 and 18. Both were there.
3 and 18. That's the 3.
Who is the appellant in this 195? What is the name of the appellant?
Pradipta Swine.
Pradipta
Swine.
Pradipta Swine, Bharati alias Dhadia.
No, this bail order is in respect of Pradipta Swine, which was passed in that CRLN number 190. So PW3, where is that line about the dying declaration? No, 3 भी कौन कौन
PW3, my lords. It is Ranjana Jena.
Who paragraph the dying declaration of the evidence law?
At the paper book, my lords, running page 103, my lords. On the way, my lords. On the way. Has that line, my lords? Third line of the top. On the way, I asked victim Sanjaya as to how he sustained injuries on his person. He told that Gunia Jena of Kuapada called him to witness Pala in the said night. After witnessing Pala, while they returned, the accused persons, namely Lakshmidhara Swine and Pamu Swine of Sunamuhi, caught hold of both his hands and accused Dhadia and Gajendra by means of stone and accused Gunia and Padya Swine, because that is the other accused member that has been granted bail, assaulted him by means of Bhujali.
Gunia is this accused.
Yes, Pradipta alias Gunia.
Okay. So this Bhujali blow has been given by you as well as that person who has been released on bail.
What 18 says?
he has come to the evidence of PW 18.
And your lordships will find that page 156.
Which para?
Second internal second page minutes.
Para.
Para minutes start with second para. Number is second.
Yes, read.
Page 157 minutes. Third line. I received the telephone from brother Onya from his mobile phone such and such that he was confined in the house of accused Lakshmidhar Swain alias Sunamuni. The door of the room was closed at the outside. Accused Gunanidhi, Podia, Lakshmidhar, Dhadia, Pramod, Purana, Gajia confined him there and watched the room at the outside. My brother raised suspicion towards the conduct of the accused person and suspected that they have made plan to kill him in life. He further told me over phone that these accused persons did not know that he was with his mobile phone. I told him to manage to escape, but he replied that he was confined in the room and that room was closed from outside.
Page 4, my lord.
I draw your attention to the next page, page 158. For a moment, my lords, if your lordship sees the third line, I found the accused persons. I found the accused persons, namely Padya, Gunia, Dhadia, Lakshmidhar, Gajendra, Purana, etc. to the said Pala ground. I came to them. Seeing me, they became perturbed. On being asked, they abused me in obscene words and told such and such minutes. Next line, abusing me in obscene words, they left the playground except accused Gunanidhi. Accused Gunanidhi told me that Ame Daki nai mote phasei deichanti emiti karibe boli mu jani nothili tu sakalu bhai katha janibu. So he was present, my lords. He was present there when he was encountered by this particular.
Come to the dying declaration.
Yes, okay. That is page 4. Third line, my lords. On the way out of pain in the Dala Auto, my sister Ranjana told him as to how he was being assaulted. Baina told that accused Lakhya, Padya, Gunia, Dhadia, Punya, Gajendra, Gajia, Pamu took him in 3 motorbike. Lakshmidhar stopped the motorbike at the spot, that is Ganapada bridge, to pass urine. Then accused Gajendra and Lakshmidhar caught hold of his both the hands and took him to the foot of the bridge. Accused Padya stabbed him on his chest. Accused Gunanidhi dealt Bhujali blow on his belly. Accused Pramod dealt incised blow on his back. Accused Gajendra and Lakshmidhar threw him on the ground, and all the accused persons brought a cement slab and kept it on his chest. Then took the victim to Pipli Government Hospital for treatment. Thereafter, my lords, the treatment went on for a day. He was shifted to another SCB hospital, but no effort was made to get the dying declaration formally recorded by him.
So he has also, according to you, in the dying declaration made before PW 18, also he has implicated that Pradipta Swain, who has been enlarged on bail.
Same role, Pradipta.
So, what is the period for which you are in custody?
Well, I've been in custody since 18/9/2010. About 14 years.
Antecedents?
No antecedents.
What do you say, Mr. Pradhan? So, is it correct that he is in judicial custody since 2010? I'll put report over the final form. Jana houchi
Gunanidhi.
Jana. Unanidhi jana custody ta court paile apono. So most likely he was not taken into custody when the charge sheet was filed. His name is not there in the final.
The submission which is filed
What
is
is arrest
like incarceration since 18/9/2010. Submission filed. That was I note of submission. That's all.
Pradeep Janar ଆଉ କିଛି ନାଁ ଅଛି କି ଏଇଟା କଣ ତା ନା ସରି ୟାର
Gunanidhi.
Gunanidhi alias କଣ
Gunia.
We are looking at that charge sheet final form. ଏତେ ଲୋକଙ୍କ ନାଁରେ ଚାର୍ଜ ସିଟ୍ ହେଇଛି ଏ କେସରେ ଦିଲ୍ଲୀପ ପ୍ରଧାନ ଦୀପକ ରାଧୁ ଯୁଧିଷ୍ଠିର ଧନେଶ୍ୱର ଜମ୍ବେଶ୍ୱର ପ୍ରଭାସ ସୋନା ମାନସ
Custody certificate is there.
ଅଛି
Yes. 14 years, 10 months, 30 years custody certificate.
last two.
Custody certificate is there. It is 14 years, 10 months. So
It is in respect of this man.
yes, Gunanidhi.
Oh, then it's all right.
Custody certificate is there.
Oh, it is typical date.
14 years.
3425. Oh, that's right. Yes, Mr. Pradhan. Or the land and counsel for the petitioner, land counsel for the state. Land counsel for the petitioner submits that the petitioner is in judicial custody for more than 14 years. To that effect, he placed reliance on the custody certificate issued by the Superintendent District Jail Puri dated 30/4/2025, which indicates
9/39.
13/34/20 indicates that the petitioner was in custody for 14 years, 10 months. 30 days. The land council submits that the co-accused Pradipta Swain, who faced trial along with the petitioner and is similarly situated, was also found guilty by the land and trial court for the offense under section 302 854 of the Indian Penal Code, and he has preferred a separate appeal, that is CRL number 195 of 2014, and by order dated 7/2/2020 in IN number 207 of 2020, he has been directed to be released on bail. The land and counsel for the petitioner provides the copy of the order which is taken on record. There are 2 copy attested marriage. The land council further submits that the petitioner is similarly situated, and it is a case based on circumstantial evidence, and the main evidence against the accused persons is the dying declaration stated to have been made before PW 3 and PW 18, and land council placed the evidence of PW 3 and PW 18 to substantiate his submission that the petitioner is similarly situated like the who accused Pradipta Swain, who has been enlarged on bail. Stop. Land counsel for the state, while not disputing that the petitioner is similarly situated like the accused Pradipta Swain, submits that twice the bail application of the petitioner has been rejected by this court, that is on 18/8/2016 in this case number 1222 of 2014, and on 5/10/2021 in IA number 936 of 2021. considering the submission made by the land council for the respective parties, the period of detention of the petitioner in judicial custody seems similarly situated to accused has been directed to be released on bail. We are inclined to release the petitioner release on bail. Accordingly, bail application is allowed. Yes, next. बाकी ऊपर जोटा थिला सेटा रहिबो तांकर जो रजिस्ट्री प्लेस करियो बोले
Item 4.
That's what the director from the state manor regarding the conduct and the custodial certificate.
आणि चंदी कस्टडी केते दिन रहिला 12 वर्ष
11 years lots.
No, it is mentioned here 12 years.
Without sentencing, 12 years, 1 month.
Okay. And what is the conduct? He was granted interim bail or what?
Yes, lots.
How many times?
That is 3 times lots. And also during post of trial also he was on bail.
No, that's all I think. We are just and to submit personally made local and confidential inquiry in village so-and-so. During inquiry, nothing adverse was found against this so-and-so person. Except the present case, of course. Okay. ये कौन हस्बैंड था 498-304
Husband man. Is acquitted. He has been convicted for 1988 and 302 and 4 degree of that.
Future acquittal है ना
304 he has been acquitted.
कितने बाहर के में
By thoughts of marriage, date of 18/5/2005.
18/5/2005.
And the date of occurrence lordship 25/8/2006.
तो ना period stipulated time भीतर तो death हुई थी कौन टा में acquittal है ला मैंने what was not proved for which
So that is the torture and the obstruction has not been proved also. And because only this evidence of the doctor, my lord, that lord had on that day was all right. And
कौन कौचंती अपनो तीन थरो गलानी तार conduct तो ठीक रहुची अपनो report दी चंदी आउ custody रे रहिलानी अपन करो 12 वर्ष रहिलानी
12 years.
So से लेटी केस रे कौचंदी जे interim bail ले गला 3 मास जीवो और तार conduct ठीक थी वो ताले that is to be extended till the disposal of the appeal, right? Or the land counsel for the petitioner, land counsel for the state. The land counsel for the petitioner submits that the petitioner is in judicial custody for more than 12 years. He has placed reliance on the custody certificate issued by the superintendent, district jail, Baleswar, which is at flag Q. He further submits that thrice the petitioner has been released on interim bail, and after availing the same, he has surrendered at right time, and nothing adverse has been reported against the petitioner. To that effect, the land counsel for the state has produced the conduct certificate of the appellant. As I say, custody certificate house at flag P. है ना?
Flag P,
certificate. हाँ?
Flag P.
हाँ. Custody certificate.
Flag Q.
है ना? What is the conduct certificate from IIC Simulia police station, which shows that nothing adverse was reported against the petitioner during interim bail periods. considering the submission made by the learned counsel for the respective parties, period of detention of the petitioner in judicial custody, the fact that the petitioner has not misutilized his liberty while on bail, and absence of any chance of early hearing of the appeal in the near future, as paper book has not been prepared, we are inclined to release the petitioner on bail allowed.
Item 5.
ପୂର୍ବ କେସଟାରେ ଆଜି ଗୋଟେ ଷ୍ଟେ ରିଏଲାଇଜେସନ ଅଫ ଫାଇନ୍ ଅଛି, ତାଙ୍କୁ କହିଦେବେ that is to be allowed. ଏଇ ଯୋଉ ଆଇଟମ ନମ୍ବର 3 ରେଜିଷ୍ଟ୍ରେସନ କୁ ନେଇଥିଲେ ହେଲା, ବେଲଟା ତ ଦେଇଥିଲୁ, ବାକି ଏଇଟା ରହିଯାଇଥିଲା ନା। ଆଚ୍ଛା, ବାକି ଆଉ ଗୋଟେ ହଉଛି ସେଠି ଦିଟା ବେଲ ଆପ୍ଲିକେସନ ଥିଲା, ତାଙ୍କୁ କହିଦେବେ IN ନମ୍ବର 275 of 23 ଆଉ IN ନମ୍ବର 1188 of 25 ଦେଖୁଛନ୍ତି ତ, ସେ ଫାଷ୍ଟ ବେଲ ଆପ୍ଲିକେସନ ଟାକୁ ନଟ୍ ପ୍ରେସ୍ କରେଇଦେବେ ହେଲା, ସେକେଣ୍ଡଟାରେ ଅର୍ଡର ହେଇଛି ବେଲ ଅର୍ଡର ହେଲା, ଆଉ ବାକି ଷ୍ଟେ ରିଏଲାଇଜେସନ ଅଫ ଫାଇନ୍ ଆଲାଉଡ୍ ହବ ହେଲା। Yes, next item.
Item 5.
Why not?
January 2025, your application is rejected.
My lord, two twice is rejected.
ଜାନୁଆରୀ କେବେ 25 ରେ?
9th January.
ନାଇଁ ନା, ତାହେଲେ କୁହନ୍ତୁ ଏବେ ରିଜେକ୍ଟ ହେଇଛି ଆଉ।
There is a direct evidence, my lord. We do 6
We do 6 and 7.
We are just adjourning it.
asserted by means of spare one go.
No.
Wait for some time.
Out of this matter, August ରଖିଦିଅନ୍ତୁ, August 2025 ଏ ତାଙ୍କ ସବମିସନରେ ରଖିଦେବେ ହେଲା, ଆଉ ଷ୍ଟେ ରିଏଲାଇଜେସନ ଅଫ ଫାଇନ୍ ଟା ଆଲାଉ କରିଦିଅନ୍ତୁ। ହଁ, এটা ଯୋଉ ବେଲ୍ ଆପ୍ଲିକେସନଟାକୁ ରଖିଦିଅନ୍ତୁ। Yes, next.
Item 6.
इसके नाम थी तो you are there.
I am there virtually for number 4.
Number 4.
Mal.
There are 5 appellants, and
Yes.
who is appearing for whom? For appellant number 1, Vishwanath Behra.
1 to Dr. Jafarullah.
1 to
Dr. Jafarullah.
no, ठीक है, be louder.
Dr. Jafarullah was appearing.
Okay.
And for 3, I was appearing.
No, question is that this IA, we are considering the bail application, and IA number 379 of 2025, it is being filed by appellant number
4.
4.
I will not take it in this.
You will not. All right.
I repeat for one of the cases, that is the case number 4 by page.
It's all right. List this matter before some other bench in which one of us, Honorable Justice S.S. Mishra, is not a party. Yes.
Item 7.
I had IDPF.
Yes, next. Item 7.
My lord, in this case, the petition is the appellant will be convicted under section 301, while he has been acquitted for offense under section 364, 366, 377. He is in custody for more than 12 years, and I have had a bail person.
Custody certificate and lay.
I have annexed that.
That is there, 12 years.
I
Agur reject ହେଇଛି?
My lord, once that is in 4/8/2023 earlier was rejected.
So a very detailed order has been passed why the bail application was rejected. What is the scope for reconsideration even if it was rejected in 23 August?
Case is based upon circumstantial evidences and
That's all right. All those matters have been considered. It's a case of rape and murder.
so for rape is concerned, I have been acquitted.
It's all right. Initially, it was a case of rape and murder. You have been acquitted of the charge under 376. The learned counsel for the petitioner submits that earlier bail application of the petitioner was rejected on 4/8/2023 in IN number 1038 of 2023. However, there was a direction to the registry to prepare for early hearing. There was a direction for the early hearing, and paper book have already been prepared, and is also ready to argue the matter and submits that the matter may be added to the hearing list. Let the matter be added to the hearing list in the week commencing from August to December. Yes, next.
Item 8.
You was filed testing on the medical ground. The report was called for. Bail application has
Just a minute. This is to be accepted because prisoner's petition has come in our name.
I have also filed the bail application.
The prisoner's petition has come in your name, so that is to be accepted, and your wakalatnama is also to be accepted.
And I have also filed a bail application, my lord, IA 1781 of 2025.
One minute, madam. Look on. Prisoner's petition has been received which is at flag G, praying for engagement of C. Kasturi as his advocate. Kasturi has filed the wakalatnama, which is accepted. The name of Mr. Jain Panda shall not be reflected in the cause list henceforth. Stop. Says Kasturi submits that she has filed a bail application which has been registered as IN number
1781.
IN number 1781 of 2025. Let the registry place the same on record.
That bail application has came, my lord. Is IA number na pe acha.
List nahi to, madam.
IA number 63.
No. Agur to gudae bail application pending achi.
Extension of interim bail.
Bail, interim bail, emso hoichi.
63. Panda was filed. Then Panda was filed 63. On that basis, the medical report was confirmed.
Have you received the copy of this interim IN number?
No.
1781 of 25?
Item 8 ବୋଲି କହିକିରି ଦେଇଛି ଆପଣ ନଥିଲେ ସେଇଠି ଦେଖନ୍ତୁ ଫାଇଲ
1781 of 25. ଅଛି ତ?
That is an interim application. Not yes. My bail application.
1781.
When have you filed, madam? 1st July. 1st July, so it hasn't come on the board.
The registry has placed the IA stop. The copy of the interim application has been served on the Land and Council for the state. Kasturi does not want to place IA number 1271 of 2024 as well as IA number 63 of 2025. Accordingly, both the interim application are disposed of as not placed. Now, whether the petitioner was earlier released on bail, then let us see the order sheet.
It was rejected on 22/10/2020.
By instruction, I have entered appearance only.
That is how
I cannot.
just see it in merit, it was rejected. And you can take this order, that rejection order in your pen drive also. You can supply this or what a count of profit your rejection order. 22/10/2020 बेल रिजेक्ट है जी ये जो सिग्नेचर ऊपर है ये पड़ेगी नहीं पकेगी ना बाकीटा दे देंगे. So you go through the rejection order, right? We'll take up this matter next week. This is Kasturi submits that she is not aware that the earlier bail application of the petitioner has been rejected. Then by the order dated 22/10/2020. He seeks for a copy of the order. Let a copy of the order dated so and so be supplied to the Land Council by the registrar. Have you got a pen drive? No, it's not like you just have a copy. All right, put up this matter next week for consideration of IN number 1781 of 2020.
Item 9.
Yeah.
It's a transfer. Already I have tried to plug my along with the concept memo also. The notes will there also be.
Noting is that you have not obtained the consent. So whether consent has been obtained or not.
Olive and also.
B. Swami and his associates.
It's
वकालत नंबर consent नहीं क्या?
separate paper.
Separate paper है?
Yes, sir.
Separate paper कहीं? ये देख लो पूरा अच्छी consent नहीं चाहिए. हाँ अच्छा right है. এটা 2019 अच्छी memo. এটা হচ্ছে नहीं ସେତେବେଳେ ଆଉ ଜଣେ advocate ଥିଲେ. Prashant Kumar Jena Swan. So this is the consent dated 14/2019 and then Wakalat Nama was filed on 19/2019. So far as you are concerned, Vishwaranjan Swai, Akash Bhuiya and Pratik Naik. সেটা তো তাদের কিছু লেখাই নেই. I have no objection বলে কোড লেখাই নেই. ଆଉ separate memory যদি ନେଇଛନ୍ତି ସେଟା ତ ନାହିଁ ଏଠି. ସେଇଗୁଡା point out କରୁଛନ୍ତି ରେଜିଷ୍ଟ୍ରି. ଅଛି ଆପଣ ପାଖରେ ତାର ଜେରକ୍ସ କପି ଟା
No objection.
Though the registry has pointed out that the Wakalatnama has been filed without taking any consent from the previously engaged counsel. The land counsel for the petitioner files a memo wherein the previous counsel has given his consent. The same is taken on record.
I have placed on the IA number 1251/23
Bail ପାଇଁ
for bail. Appellant convicted or
ଆଗରୁ ରିଜେକ୍ଟ ହେଇଛି ଆପଣଙ୍କର
already 2 times rejected. 11/1/2021.
9/1/20 ଆଉ 11/1/21
ଗୋଟେ ଥର ତ ରିଜେକ୍ଟ ହେଇଛି ଆଉ କୋଉ ଥର
9/1/20.
9/20
9/1/20 ଥରେ
651 IA number 217 out 1028 IA number 20.
କଣ ବର୍ତ୍ତମାନ କେତେ ବର୍ଷ ରହିଲେଣି ଆପଣ
More than 14 years, let's say.
କାଇଁ ଇଏ କାଇଁ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ କାଇଁ ଅଛି ଆପଣଙ୍କ ପାଖରେ ଆପଣ ଆଣିଛନ୍ତି କେତେ ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ଅନୁଯାୟୀ କେତେ ବର୍ଷ
14 years.
ଆଚ୍ଛା ଲେଖନ୍ତୁ IN number 1251 of 23. The Land Counsel for the petitioner submits that the petitioner is in judicial custody for about 14 years. The Land Counsel for the state seeks some time to produce the custody certificate as well as to take instruction on the criminal antecedent, if any, against the petition. Put of this matter in the week commencing from 21st July 2025. Yes. Just out a line the name of the earlier engaged counsel shall not be reflected in the cause list henceforth.
Item 10.
Mr. Mahapatra, you are appearing for all the appellants. What is this prisoner's petition has come? Have you seen the list, Mr.? Prisoner's petition has come that for engagement of Mr. B. Dalai for appellant number 1 instead of Mr. D. Panda, then so and so has filed the Wakalatnama for appellant number 2. Then prisoner's petition has come for engagement of Mr. P. Mahapatra for 1 and 2. No, it's all right. No. Tale aguru uda astla to prisoner's petition flag X-ray. Ita recent ta. Flag K ta date. Prisoner's petition.
December 2024.
Rabindra Kumar Ojha, Dr. Kumar Ojha. Yes, you can place the matter. You can place the matter.
My lord, this present petitioner was taken into custody on 24/3/2012.
Mr. Mahapatra, there are, I think, one IA is for the appellant number 2, another is IA for bail, and that is IA number 1258 of 25. So, who IA ta apna press kariya chahunchhanti?
1258.
1258.
সেটা কোন সমস্ত পাই ফাইল হইছে না রাজেন্দ্র কুমার ওঝা अच्छा এটা তাহলে appellant number কেতে ସିଏ
1
ओके appellant number 1 ଆଉ ଏଇ ଯୋଉଟା ଫାଇଲ ହେଇଥିଲା ଆଗରୁ IN number 2531 of 23 for appellant number 2 এইটা ବର୍ତ୍ତମାନ ପାଇଁ ରହିବ ନା ଆପଣ ଗଡ଼ିବ ଆଚ୍ଛା ଖାଲି ଏଇଗୁଟା ପ୍ରେସ୍ କରିଦେବେ ଆଚ୍ଛା ପ୍ରେସ୍ କରନ୍ତୁ whether your bail application was earlier
Yes.
rejected appellant number 1's bail application
I order dated 21/12/21.
just a minute
1258.
appellant number 1 ହେଲା ରବୀନ୍ଦ୍ର କୁମାର ଓଝା rejected on କୁହନ୍ତୁ ଡେଟ୍ ଟା
21/12/2021.
21/12/2000 ଥରେ ହେଇଛି ରିଜେକ୍ଟ
ଆଜ୍ଞା
21/12/2021 ଆଚ୍ଛା ଖାଲି ଲେଖା ହେଇଛି ନଟ୍ ଦିସ୍ ସ୍ଟେଜ ଓକେ ସୋ you have got the deposition copies with you?
Yes.
Yeah. What is the case and 302 502 eyewitness section दिला eyewitness
Eyewitness is there. I am not going to the merit of the case at all. He was taken into custody on 24/3/2012 manner.
what is the age of this man?
More than 70 years today. As I'm told, more than 70. I have filed the documents showing the date of birth.
Okay, so he was taken into custody on
24/3/2012 manner. And since then continuously he is in custody.
what is your instruction about that Nalsar jo
We have to take instruction.
हाँ
Just IAS copy serve on
हाँ हाँ
1st May.
नालसार से जो गाइडलाइन आई 70 वर्ष और टर्मिनाल इलनेस रो एटा बुझी दियंतु एज रे जदी एसेंस दैट इज द एंटाइटलमेंट को जेल अछि 14 नेक्स्ट वीक नहीं आसुन हां फ्राइडे रे नेक्स्ट फ्राइडे रो अछि अवेलेबल लखन द आईएन नंबर 1 शो
खाली ମୁଁ ଟିକେ ଇଣ୍ଟରଭ୍ୟୁ କରୁଛି ସେ ଜଜମେଣ୍ଟରେ ଅଛି ରବୀନ୍ଦ୍ର କୁମାର ଓଝା ତା ପ୍ରକୃତ ନାଁ ହଉଛି ରବୀନ୍ଦ୍ରନାଥ ଓଝା ସେ ଗୋଟେ କଣ୍ଟ୍ରୋଭର୍ସି ହେଇଯିବ ତ
अच्छा हाँ लिखो IAN number 1258 of 2025 this is an application for bail filed by appellant number 1 Ravindra Kumar Oja alias Ravindranath Oja. The Mr. Mahapatral and senior advocate appearing for the petitioner submits that earlier bail application of the petitioner was rejected as per order dated 21/12/2021 and the petitioner is now about more than 70 years and he is in judicial custody since 24/3/2012. The London Council for the State seeks some time to obtain instruction regarding the age of the petitioner, so also to produce the custody certificate. Put up this matter on 11th of July 2025. Next week. Rest of the matter, asivo sombar din.
I may be permitted. I'm just handing over the written notice of submission, which one is reserved by your lordship yesterday. That criminal record which your lordship has reserved yesterday, just handing over the written notice of submission.
Item number 11 kindly call the matter on Tuesday because I will leave on
Tuesday रे आउ जो Thursday रे आउ separate bench होची
ସମାଧାନ ରହିବିନି ଯିବି ଟିକେ
ଆଜ୍ଞା ବୁଝିଲେନି सोमवार बुधवार ଆଉ शुक्रवार ଆସିବ ତେଣୁ ମଙ୍ଗଳବାର ଆଉ ଗୁରୁବାର ଟାକୁ ଛାଡିକି ଆଉ ଯୋଉ ବାର କହିବେ ପକେଇଦବା
except Monday any day except Monday
ତାହେଲେ ଆଉ ଗୋଟେ
ବୁଧବାର ଦିନ କରିଦେ
ବୁଧବାର
except Monday
ବୁଧବାର
ସେଇ ମ୍ୟାଟର ଟାକୁ ଲେଖି ଦିଅନ୍ତୁ ହେଲା
obliged